You want to appear for your exam. Very good. Superb. Okay, Sanchita, you have the link for the presentation, or should I send it to you on WhatsApp?
Can you please send it?
WhatsApp works?
Yes, WhatsApp works.
Okay. So hi everybody, welcome to the session on how newcomers can set up a practice at the Supreme Court. This is Abhyuday Agarwal, COO and co-founder at LawSikho, and I have with me Sanchita Ain, an advocate on record at the Supreme Court. She does a lot of matters independently, and she's also Mr. Salman Khurshid's junior. Okay, and she's inviting a guest speaker today for the session. She's inviting a Bombay-based successful lawyer, senior lawyer, who also travels to the Supreme Court for a lot of work. So he will be there shortly with us. So today is going to be a very exciting session. You're going to see how trial court lawyers, high court lawyers, how they can build a Supreme Court practice, how freshers can build a Supreme Court practice. A very, very cutting edge space we are covering. Okay. And we did a lot of research because, you know, it's not a standard thing for people to think that this is the straight line path to work in a Supreme Court. The path is very, very, one has to dig through many layers. So we have prepared some roadmaps for you that you can use to build a Supreme Court practice. Okay, and if you go in a disputes practice of a law firm, why and how you can use Supreme Court expertise, all of that we have explained. Okay, all right. So Sanchita, I've shared the presentation also with you, and I can run it while people join in. Okay, so we're going to start now. Thank you everybody for joining in here. Okay, I'm getting a sense of who all are here. Thank you for sharing about yourselves. Okay, over to you, Sanchita. I will help you with presentation if you want.
Right, or else if you can give me a moment, I can share.
I'll just do it. I'll manage it, don't worry.
Okay, perfect.
Just help me focus like that.
Yeah, perfect. Okay. So how did I start? Let's first start from there. How did I start my practice? I started off with Supreme Court, but how did I start? Let's go to the next slide. I did 2 internships with senior advocates when I was in law school. One was with Mr. Salman Khurshid when I was in second year, and then I did an internship with Mr. Parag Tripathi when I was in my final year. He was in ASG at that time, so it was very, very exciting to work with him and see the kind of cases he was handling and the number of cases that he would handle. So it was a very, very different experience altogether. Yeah. So after my law school, I went to do an LLM. Once I was back, I was hired by an advocate on record who was junior to Mr. Parag Tripathi when I was interning there. This advocate on record had just started off like 3 years and he was building up his practice, and that's when he hired me. So this is the time when I got the opportunity to see how he was building a practice. Then I joined the chamber of Mr. Salman Khurshid. Yeah. But before doing that, I had to ensure that I had spent enough time in a drafting chamber, honing my research and drafting skills, because once you are in a seniors chamber, then you do not get to do so much of drafting, etc.
So your drafting basically, your internships were very helpful in identifying your first job, and you started directly with the Supreme Court.
I realized that this is a place where I want to work.
So you were a newcomer who set up a Supreme Court practice.
Oh, yes.
Okay, good.
Yeah. So the point I'm trying to make here is I had to spend a longer time working with an AOR because it took me that much time to learn drafting and to get there where I could assist a senior effectively. So it was only after that I joined Mr. Khurshid. I had got an offer, but I had to wait for 6 months because I realized I was not ready. Once you start working in a senior's office, then you, of course, don't go back.
So in 6 months, you learned the drafting work at the AOR's office?
So 1.5 years, actually. So after a year of practice, after 6 months of practice, I was offered a position. I waited for another 6 months. Then I joined part-time. I continued to do drafting work in the AOR's office, continued to assist Mr. Khurshid after 3-4 months. So it was effectively 1.5 years.
Got it. Got it. And by the way, for all of you, today we are going to help you see exact roadmaps on how to go about building a Supreme Court practice. And those of you who are staying in this session for 3 hours, for the full session, okay, please schedule yourself till 9 p.m. Those who stay till then will get access to one free recorded session of Sanchita. It was a pre-launch session on this course where the vision for the Supreme Court course has been shared by Sanchita. You will get free access to it. Remind me at the end, I will share details on how to get access to it, where to mail. Okay. And yeah, so for that, you will have to stay till the end. Those who stay till the end of the session will get that access. We will see at the end of the session, when you send us a mail, we will see that you participated till the end or not, and then we will give you the access. Okay. So those of you who stay will get this offer. Okay. This is free. Okay. Absolutely free. You will get this exclusive session. Okay, go ahead, Sanchita.
Yeah, so I would have got 7 times more with Mr. Khurshid if I would have switched. It took me 6 months to make that choice, to make that decision, just because I was still learning drafting.
And if you had learned it, you could have directly taken that offer.
Oh, yes.
So 7 times more and 6 months earlier.
Oh, yeah.
Wow. Okay. So you didn't learn drafting with Mr. Khurshid, you learned drafting at the AOR's chambers, who was the junior.
No, you don't learn drafting at a senior's office. This is a mistake that sometimes law students would make. But if you do an internship with a senior, you would know that there's no drafting work that's done.
Right.
Right. Yeah. So that's the thing, that you're not taught how to draft petitions in a law school, let alone petitions for the Supreme Court. So I had to make mistakes, learn from them.
Did anyone learn drafting a Supreme Court petition at law school? By any chance, even in a guest lecture, sometimes you have guest lectures on SLPs or constitutional law. Did you learn that? Sometimes famous advocates come from high courts and Supreme Court. Sometimes you do moot court drafting. All the moot court petitions for domestic moots, by the way, if they go to Supreme Court, you are actually doing SLPs, but you're not drafting with respect to Supreme Court rules. You are drafting based an SLP, but in a moot court format. If you file that at the Supreme Court, it will get thrown out. Okay. Okay, go ahead, please. Sanchita, please proceed. Yeah.
Right. So I definitely had to make mistakes and learn from them, right? Because nobody really, even when you join a chamber, nobody is going to train you in drafting. You have to make mistakes and learn. That's how it works. Right. So you're obviously expected to already know how to draft. You're at the most given a format and you're asked to start drafting. Yeah.
So this is standard across everywhere, like you might have senior lawyers, but it's not that they will have some special sympathy for you ki bhai abhi aaya hai, hum bhi aise the. And I constantly meet senior lawyers and talk to them, and they say that young law students today are brighter than earlier. But the point is, are they bright enough for you to be hired and to start earning and to hit the ground running? That they always say no to. And then in your first year when you are working, they are very clear that they want you to contribute and somehow figure out what you need to do. And if you tell them, sir, hum kaise prepare kar sakte hain pehle se, then they are like, it will come from experience or it will come from practice, koi tarika nahi hai, simply because they don't have a prior memory. LLB college mein unhone nahi seekha tha. So they will say ki karte karte seekh jaoge, but kaise seekhna hai, they'll say, figure it out. Work hard, spend 18 hours.
In fact, nobody has the time or energy for it because everyone is overworked.
True.
Yeah, so at the most you're given a draft that we'd filed this just 2 weeks back. Have a look. This is the format you have to follow and draft it. But it's a good draft, bad draft, nobody is going to tell you. So obviously learning how to draft and just using a format at completely different aspects, right? You cannot confuse them. Sometimes you send a draft to somebody and the person thinks, oh, this is how I have to do, this is what I need to copy paste, and comes out the facts were very different. Everything was different. So all you had to use that draft for was just for the format.
Yeah.
Effective drafting is a function of case research, analysis. So drafting does not just mean that you have to just write the cause title and if you make everything right, it will be right. No, it involves a lot more than that.
So actually, there are so many things that the slide got filled up. Effective research, analysis, grip of Supreme Court precedent, knowing the rules, the powers of the court, identification of the issues, procedural requirements, knowing the hearing process. You have to know that when you're drafting also. Knowing how to write and communicate and flesh out your argument. Okay, all these things you must know, otherwise it's not going to work. Okay, including how to prepare briefing notes for senior advocates. Because if you're drafting, you'll go and brief the senior also, and you want to know even that kind of drafting where you can prepare some kind of charts for senior advocates. Sometimes you want to give these notes to the judges. Okay, that okay, I have a 500-page petition, but this is the note which will explain the whole matter. Okay, and that needs drafting skills. That needs that clarity. You want to see the last slide? I don't like the picture of it, but okay, go ahead. There's a lot of content.
Yeah.
Go ahead.
Yeah, I think
Donita, you can see this. Yeah.
Yeah, so effective drafting is not just about the format, it's about how you research, come up with the right cases, then you analyze those right cases. And not just that, even before doing that, you need to know the powers, etc., of the Supreme Court, the rules, everything. Yeah, so in a senior's chamber here, senior would mean a drafting counsel. You're expected to draft just like your senior. So when he goes through a draft, he'll be like, oh, it's not up to the mark. Do it again, or redraft it, whatever. Do whatever, just bring something better. That's what happens. There's no room for excuses, explanations, no matter how valid they are. It can cost you your job. I mean, they keep getting frustrated, particularly in adversarial system in litigation. When you start working, it can be a very hard experience sometimes initially. You would be yelled at a lot many times just because, and you'll get there. I mean, after a few years, you'll get there. By then, you may have had to switch.
So there are two kinds of costs. One is a real cost, and one is like, being shouted at. Being shouted at may or may not be a real cost depending on how you take it. But if you constantly keep getting shouted at, your self-worth kind of erodes over time. Okay, and it's not easy to perform when you're in that environment. Another way could be, that seniors may just not prefer to give you a lot of responsibility or more than you can handle. The third thing is that you will not be able to grow as much as you want to because you'll not get the work only. Okay, so you're paying in terms of deferred income or in terms of income. Like Sanchita said, 6 months earlier, I could have got 7 times more. It's insane, right? The kind of difference that'll happen. So what people think, okay, is that my failure to perform with a good reason is equal to the job done, is equal to the performance. Whereas in reality, it is not. Agreed? Say agreed or disagree. So there's no point in making reasons, especially if you have an opportunity, an option to do something about it. If you don't have an option, obviously hard work, trial and error, getting blasted at is the only way. But where there's an option, then you can look at things. There are harsh realities to deal with. What are these harsh realities? Okay, I will quote from these, okay? This article, it's there by Hindustan Times. 74% of lawyers in 5 high courts, Allahabad, Bombay, Gujarat, Kerala, and Madras, said that senior advocates in high courts charge upwards of 80,000 per hearing. Okay, but 80% of the surveyed advocates from the high courts said that the average monthly income for juniors is 5,000 to 20,000, and this is in Delhi. Delhi is the highest. In other places, it is Calcutta and Gujarat, it was up to 5,000 to 10,000 maximum. Kerala, Madras, Patna, High Court, okay, juniors were earning up to 5,000 only. And I've seen, like, I think there's one state bar council which has made regulation that juniors must earn at least this much amount in the first year or first 3 years of practice. Some bar council or bar association has made in one state. Now, question is, why is the income so low? Is it that they, and it's very easy to spin this around into something that, seniors should pay more, they are not paying us. But I kind of don't agree with, just making a righteous moral claim there. Okay, several young lawyers believe that this is reflective of a poor legal system, our culture is bad, or seniors are bad, or they don't have a heart. But that's not really the case. It is simply a function of your skills. The workload for a senior is so much that they don't have the time, they don't have the energy to edit your documents and drafts, even if they want to. The expectation is that you will do a spot-on job by yourself. Nobody has the time to train you, despite the best intention. It doesn't matter if they intend to train you, but they don't have the time. When you start working in a senior advocate's chamber, expectation is that you already understand the nitty-gritties of law and which argument will work and which argument will not work. Without skills, your claim for remuneration is going to be based on charitable or humane grounds. And that's what people say, right? The ones who criticize, they say that it is, inhuman to pay so little for so much work and you're exploiting us. But hello, they will exploit you if they can get something relevant out of you. But if somebody is going unprepared to a lawyer's chamber and is not able to effectively contribute, then they will not be able to pay unless it is on charitable or humane grounds. Now imagine that there are some good lawyers who do that. Okay, the thing is that every lawyer will not be able to accommodate juniors on these grounds.
Even if there is a good lawyer Abhyuday, the point is, if you cannot demonstrate your skill, nobody would be willing to pay. Even if they have the capacity, they won't be willing to pay. That's very important to understand, that you get to fix your own price. Sometimes people say in litigation there's no money, but you get to fix your own price here as well.
Yeah. So the few seniors who will, be charitable or humane, they'll be inundated. Everybody will go to them, sir, ma'am, please give me a job. Then what will happen? They will not be able to accommodate every junior. So whatever happens, the point is that if you're not able to fit into the structural system, like the economic structural system of the court, they will not be able to accommodate a junior, right? Now, in all, the system is going to fail without the necessary skills. If they also didn't have the skills, they wouldn't be able to charge what they charge clients. It's not that they're getting that money, 80,000 per hearing for free, right? There is some effort they've put in, there is years of work. If for 1 hour, if for one hearing in 5 minutes or 20 minutes or 2 hours, they can claim this, they've put in all the past years of experience they've put in into that way of thinking. Acquiring more skills, therefore, can reduce the amount of time it takes to succeed. You have Sanchita's example. She said 6 months earlier, 7 times more. Now, learning Supreme Court work gives you certain advantages as a fresher. Okay, what are the key advantages? We did a lot of research and we found out that, there are some specific examples. Unlike high courts and trial courts where there is disparity. Delhi High Court different from Calcutta High Court, different from Madras High Court, different from Patna High Court. There will be standardization of fees in Supreme Court, right? Supreme Court lawyer won't say, I've come from Madras High Court, I'm going to pay my juniors less. Right? There will be lawyers who start to follow a standardized structure for getting the juniors, because otherwise they will not get juniors, right? Tell me if you're with me on point 1, okay? Second, focus on drafting skills at the Supreme Court is the highest. This is the one court where people care the most about having the right quality of drafting. Okay, people care about the drafting being detailed, meticulous. In a trial court, you may get away with bad drafting from time to time, but here it will not work. You may get away with small technical procedural loopholes in argument stage which you didn't cover in your draft, but Supreme Court में ये सब नहीं चलेगा. Drafting charges for Supreme Court work is higher. इसका मतलब क्या है कि there is importance of it also, and the remuneration correspondingly is higher. ऐसे नहीं है कि it is shit work and you are being paid less for a lot of work. No. Clients are paying more for this work. Lawyers are paying juniors or people who draft for them on a freelance basis also more per draft, right? The drafting charges are much higher. Drafting is a time-taking and complex task for lawyers, but very remunerative. अब इसका आपके लिए क्या फायदा है if you're a young lawyer? See, right now I'm not talking to, I believe, okay, you all can correct me. I believe a lot of you are young lawyers. You don't have like 10 or 15 years of experience. Okay, if you all have, then you tell me, okay? But a lot of you are freshers, you all are law students. Now, what is the advantage for young lawyers agar drafting is remunerative and complex? Senior lawyers will prefer to focus on their argument and client acquisition. एक बार उनका career take off कर जाता है, तो they start to focus on this, and they will delegate drafting work to junior lawyers. चाहे वो उनके खुद के juniors हो या बाहर से कोई उनके लिए अच्छी drafting करते हैं तो, provided the juniors can draft well. इससे उनका drafting में क्या है ना, argument के comparison में बहुत ज़्यादा time जाता है, ठीक है? So when a senior lawyer wants to specialize, they'll look into the briefings, they'll go into argument, client, business development, but they'll not want to handle all the drafting work. They'll want a stable team to do this. Good law, and this is not senior advocates I'm talking about, okay? I'm talking about senior AORs, lawyers who can file at the Supreme Court, okay? Senior advocates क्या तो argument का काम रहेगा. They will not be filing at the Supreme Court. They may refer some clients to you who need something to be filed, in which case वो काम आपके पास आ जाएगा. But आपके पास ज्यादातर जो सीनियर लॉयर्स हैं जो ड्राफ्ट कर जो फाइल कर सकते हैं, ड्राफ्ट कर सकते हैं मैटर्स, एओआरस जो हैं सीनियर वाले, मतलब 10 साल 5 साल 8 साल 12 साल का एक्सपीरियंस वाले वो ये काम देंगे. Second, good lawyers can get more matters than they can actually work on. ये same senior lawyers who I'm saying ना, they'll want to argue, they'll want to do client meetings, they'll want to do briefings, right? So they will not want to focus so much time on drafting, but वो लोग को इतना काम रहता है, they can't take on more work. Why? Because somebody needs to draft. Pathetic drafting won't work, and they don't have enough supply of good drafting juniors. Okay, even if you have 2 good juniors, how many matters can they work on in parallel? Limited number, right? So what if I can argue all the matters, because argument doesn't take my time and I'm smart enough to catch the argument, but I need like 6 parallel petitions to be drafted on one day. अब वो कैसे करूंगा? अगर नहीं कर सकता तो मैं क्लाइंट को डिले करूंगा. अगर आपके उस चेंबर में होने से वो ड्राफ्टिंग हो जाता है तो उसका बेनिफिट किसको होगा?
There's a request not to use Hindi.
Okay, I will not use Hindi. In my webinars, people want Hindi. Okay, cool. So I'm saying, how is it going to be beneficial for you? Because a good lawyer will get more matters than they can handle. Why? Because drafting will be the thing that will take their time off. So now they cannot ignore drafting, but if they don't have enough supply of good drafting juniors who can do enough drafts, they have to focus. Then they have to do whatever I could do. If the day client came to me today, I could deliver in 48 hours. If I had a good team, I'll have to do it over the week. 6 days it will take. How does that affect my practice? I can take 1/3 the number of matters than I could have. So if I have a good junior who can draft well, okay, I can take 3 times the number of matters. That's the kind of junior I'd want to pay. Okay, but if I have a junior who I only need to spend my time on teaching, then my current number of matters will also go down. Okay, that's the difference. Right? Okay, so how many of you are with me till here? I'll try to use a combination of English and Hindi. Otherwise, because see, English is already on the screen, but I will just if you can't follow English, let me. All right, so Supreme Court drafting is not bare bones drafting alone. What does this mean? The same thing that I said earlier, that you have to research, you have to put things together, you have to see Supreme Court rules, you have to do a lot of things together. You have to see the ratio, the legal arguments, the complexity, all of that is much higher than in a regular civil suit, in a regular trial court drafting. Okay, so superior drafting skills are most important here. Now we're doing this work day in and day out to be able to bring you the skills. So now we're going to take some important questions. Should you first start practicing in the district court, then the high court, and only then think of setting up a practice in the Supreme Court? This is a very popular question. People think that, guys, don't fight over what Hindi is our national language or regional language. It's okay. Should you then first start practicing in the district court, then high court, and only then think of Supreme Court? Or should you think I should know trial, high court, and Supreme Court together? What will help? Okay, Sanchita, your expertise on this question is needed.
Yeah. So I think many of you will have this question. So let's see if you should start first with district court and then go to high court, then to Supreme Court. Let's go with it.
Okay.
Yeah.
So technically you can go to Supreme Court, but the point is not about technically I can go anywhere. But point is it feasible? Is it advantageous? Right? The real question is it going to benefit me if I directly think of Supreme Court? Okay. Should I do this part? Few things I had written. You can add in. Okay. So the thing is that there's no connection between trial court or high court drafting with Supreme Court drafting. Okay. And Sanchita will also share her inputs. Yeah, exactly, Prashant. This is what you have to think of. Okay. That how do you get into the chambers and how do you learn actually this? There's no connection between high court, trial court. Why? The entire jurisdiction of Supreme Court is different. Substantive issues are different. Procedural rules are different. Supreme Court jurisdiction flows from a different set of provisions under Constitution as compared to anything else. Okay, there are various statutes which grant the Supreme Court appellate jurisdiction. That is not there with the high courts. Okay, so Supreme Court has appellate jurisdiction under certain statutes which high courts don't have. Supreme Court has made specific rules for practice. Civil Procedure Code and Criminal Procedure Code filing and drafting principles are not followed there. Okay. High courts follow CPC and CRPC with minor state amendments. Okay. Under the CPC, there are orders. Those orders, the text of those orders can be amended by the high courts in each state. But in Supreme Court, the whole procedure is very different. It may have borrowed from the CPC, but there is a whole different procedure. So if you want to learn really the rigor of drafting for litigation, okay, drafting for litigation you want to learn, it starts at the Supreme Court level. Okay, now why is Supreme Court drafting better? Okay, Dia, we will address your question, ask in Q&A. Okay, so everybody, you have very important questions. If I start answering the questions, we go off topic. So you want to hold your questions about how to approach Supreme Court advocates. You heard somewhere that you should first practice in lower courts. So try to understand the logic that I am giving you. Okay, you don't want 20 people saying ye bhi ho sakta hai, ye bhi ho sakta hai, this is also possible. You want the logic. So if you want to learn the rigor of real drafting, starts at Supreme Court level. Now lawyers are advised to be careful in the initial years of practice about whom do you start with, what kind of matters you do, which forums you argue in. Why? Because you should not learn the wrong kind of habits. Some lawyers even say don't worry about billing because you should focus on learning. What are the wrong kind of habits? Okay, cutting corners in your drafting, using minor procedural arguments in court and not worrying about your drafting. All this senior lawyers advise that when you're starting your drafts, you should not, you're starting your career, you should not be doing that. So now earlier, Supreme Court opportunities for young lawyers were very, very limited in the Supreme Court. Okay. Now, why were opportunities limited? Many senior advocates didn't pay well or didn't pay at all. Right? How many of you are aware of this situation? You can say yes. Right? You don't have to look at going to NGOs. These are not connected tasks. Okay. You can do it in parallel. Don't do first, second. I'll tell you how to combine careers. Okay. But now what's happening now? There are way more matters. There are many more lawyers who start practicing in the Supreme Court right after college. Okay. Sanchita Ain herself is an example of such a lawyer. Judges are encouraging young lawyers to go and argue. And I'm going to give you examples. And this is from the media. Okay. In fact, there was a movement to restart physical hearings at the Supreme Court. You know why? On the premise that senior lawyers can practice in multiple states sitting from their home. But young lawyers used to go to courts, meet a lot of seniors, and that would help them network a lot more to meet new seniors, to brief them in future if matters came, or to perform various kinds of work. So for wherever the lawyer to lawyer networking used to happen, sometimes for that physical hearings were important. Physical presence in the courts was important. Now, what is important here to note is that people are caring way more about young lawyers today than it was the case before. Okay, Justice Deepak Gupta and Justice D.Y. Chandrachud encouraged young lawyers to act for independence of the judiciary. You can see this post on Outlook India in May 2020. Chief Justice Deepak Mishra stated that young lawyers could mention cases out of turn at the Supreme Court. Initially, it was about whether only AORs can mention it. AORs meaning at least you would need to have 5 years of experience and crack the exam, versus whether you need to have versus a lawyer who's not even an AOR can mention. And it was clarified that even a non-AOR can mention the cases if they learn mentioning. Okay, that was one gap area. So how to mention cases was something that was necessary to be learned. Sanchita will teach you that in the Supreme Court course for those of you who decide to take it up. Supreme Court designated 5 lawyers at the youngest ages possible in the history of India to senior counsel position. Now, earliest ages, like there were 5 lawyers around 41 years of age became senior advocate. Okay, I think there have been people at around age 38 also, but in this March 2019 round of designation, there were 5 lawyers who were at around age 41, 45, at which they got designated as seniors. These are very young ages for somebody to become a senior advocate. 9, and then there's a list of 9 women lawyers who are doing extremely well at the Supreme Court. Only 9 were listed here, but there are way more women lawyers. So it is not that litigation or Supreme Court litigation is only for men. It is for everybody. Okay, the opportunity is available for everyone. Now there are several. Now we're going to go into how does it work. Okay, Sanchita, are you here? So there are several rounds of litigation in the same matter, appeals and SLPs. So I am going to just start this. I cannot email the PPT right now. We're going to continue with this one. I'm just reaching out to Sanchita. Okay, so I will continue. Sanchita is having an internet problem. She'll just be back right away. So the thing is that any matter, before it even completes, okay, can go to Supreme Court in the middle only, through appeal or through special leave petition. And this can happen even in a civil matter or a criminal matter before trial is completed. You know what trial is? Trial is the stage where all the evidence and everything is taken. This can be completed even before. Okay, so you will have interim applications, SLPs against interim relief going to Supreme Court. Okay, just give me a second. I'm just checking with some. Appeals and SLPs are filed against all sorts of interim orders even during the pendency of the matter. Okay, Supreme Court work is important for the following kinds of lawyers. What are the kinds of lawyers who are there? NCLT lawyers. Appeals go to NCLAT and the Supreme Court, right? From so I'll tell you which section also. Section 62, check of insolvency and bankruptcy code. Okay, their appeals will go from NCLAT, NCLT, NCLAT, and then Supreme Court. This route does not involve the High Court. Sanchita, would you like to share? Would you like to continue speaking here? Or you want me to take this part?
No, it's okay, you carry.
Okay, SLPs against various kinds of NCLAT orders. For example, under section 29 capital A. Okay, so special leave petition is one of the important things that Sanchita focuses on teaching, and this is also covered in the Advocates on Record exam. Now, SLPs against NCLAT orders, very important. Anybody wanting to practice at the Supreme Court must know how to draft SLPs. But SLPs under different laws are worked on differently. Competition lawyers need to know how to go to Supreme Court. There's section 53T of Competition Act requiring you to go to Supreme Court. Section 261 under income tax law requires you to get to, this allows you to go on appeal after getting a certificate from High Court to the Supreme Court. Okay, arbitration lawyers, I'm explaining, okay, so that you can understand the whole litigation pathway. For arbitration lawyers, there is domestic arbitration work and international commercial arbitration work. In international commercial arbitration work, there's a whole procedure about how to get the arbitrator appointed in an ad hoc arbitration, okay, or in an institutional arbitration where the institution is not doing its job. So there you have to go to the Supreme Court. In domestic arbitrations, you have to go to the Supreme Court in these matters. Where there is a section 37, don't worry if you can't learn the sections, don't have to learn, okay? This is just the first time you're hearing about this, but just understand that Supreme Court has a very unique set of matters coming to them. And when we are looking at Supreme Court practice, we have to know the history of what kind of matters are going there. SLPs, for example, arising from section 37 or other related matters, okay? There are section 934, okay, SLPs can arise from there. Appellate matters go to the Supreme Court from the tribunals in the statutory appeals. High Court lawyers don't do that work. For criminal lawyers, statutory appeals are there under this Supreme Court Enlargement of Criminal Jurisdiction Act. In certain matters only from High Court, it goes to Supreme Court in an appeal, very unique to criminal lawyers. You want to build a criminal law practice, you must know Supreme Court work for this. Then there are SLPs against various orders of the High Court, quashing of FIR, after charge sheet has been filed, quashing of FIR and the charge sheet, revision against order on charge, anticipatory bail related matters, interim bail related matters, regular bail related matters. Those of you who attended my session would have seen that. Protection order while hearing a bail or a quashing petition. Okay, substance can go beyond IPC in criminal matters, whether you're doing Prevention of Money Laundering Act, Anti-Corruption Act, Fugitive Economic Offenders Act, any of this. For corporate lawyers, there's a combination of the scenarios, like you can use tax, you can use competition, you can use arbitration, you can use NCLAT. So if you're working in the disputes practice of a law firm or shifting from corporate to disputes, these are the important areas to keep in mind. Okay. How many of you are with me till here? Did you follow what is the combination? So when you're thinking of Supreme Court practice, you have to look at this: tax plus arbitration, or corporate plus or competition plus tax plus Supreme Court, arbitration plus Supreme Court, competition plus Supreme Court, like that. Now, the reason why young lawyers are not able to earn enough in litigation is because there is insufficient depth. Most young lawyers stick to entry-level work in NCLT, check bounce cases, other NI Act cases, civil and family court matters. The problem, now, do you agree with this part? Have you seen people in your network who are sticking to this and then they hit a barrier? Their barrier, they are not able to cross. Okay, now look at this. Elon Musk, right? Now is the richest man on earth. Okay, said that you will be paid in proportion to the difficulty of the problem that you solve, right? And this is an intuitive statement. Agar aap difficult problem solve karoge, you will be earning more. You will be more successful if you're solving difficult problems. Now the problem is that the matters before pure civil courts, pure criminal courts, or just under NI Act, okay, so let's look at civil courts and criminal courts. NI Act is different. For NI Act matters can be simple in certain cases. Matters before civil and criminal courts can drag on for very long. So one has to choose the areas to specialize in very carefully. Why? Because they're dragging on for very long. So how do you offer more services and charge more to the client? Okay. Commercial matters which are before tribunals, they move much faster. There is more likelihood of negotiation and out of court settlement based on what's happening in the courts and tribunals. In criminal matters, certain aspects of criminal matters, the stakes are higher when it's a question of bail, appeals against conviction, acquittals or sentencing. This is where again you have to look at, okay, how can I get my client to the Supreme Court? If you are now also, if you're interested in doing constitutional law matters, how can you start from the trial court? You got to start from the Supreme Court. Sanchita, would you like to please take it from here? I will move the PPT if you want.
Right. So the point I was making was when the people say the traditional view is that you need to start from the district court, right, and then go to high court. But if suppose somebody is interested in doing constitutional law matters, then how would it help to start from district court? Do you think it's going to help? No. Right? Right. Next slide, please. If you could.
Okay, so a lot of you may not be practicing in any of these forums, but if you want to build a career in litigation, this is how you need to think of from now itself, that these are the matters, this is how they'll start, this is how I end up in Supreme Court. You need to think of the end game. Can't leave things to chance. And by the end of the session, you can build, you'll know how you can build a pathway in this direction. Yeah.
Right. So would a trial court lawyer have any advantage? Because some people say that there are things you get to learn only in trial court, and therefore you should start from the trial court. So let's see if a trial court lawyer will have any advantage. So most Supreme Court lawyers continue to, I just can't.
No, this is incorrect. I think this is an older version. Hang on, okay?
Okay, anyways, I'll talk about it. Don't worry.
You can do that.
So the thing is, a trial court lawyer definitely has some advantage to the extent that they get to deal with the procedural aspects in a manner that a Supreme Court lawyer does not get, right? So Supreme Court lawyer does not, for example, cross-examine a witness. So what are the intricacies involved in cross-examination? And if there is something of a sort that's only procedural in nature, that is something that relates to the practice of a trial court, then only a trial court lawyer would know that. Agreed. But once the trial stage has happened, trial court lawyer has argued, the matter goes to before the High Court. That point has already been raised in the High Court. The petition would cover that. The impugned order will cover that, and then the matter goes to the Supreme Court. So therefore, when you're arguing before the Supreme Court, you're only confining to a question of law. You're only confining to what is already there on record. In fact, if you have to file something more than that, you need to seek permission. Therefore, when you are practicing in Supreme Court, it requires completely different set of skills that has got nothing to do with the skills that are required in trial court. For a trial court practice, you need to be very good at cross-examination, right? But for Supreme Court, you don't need that. You need to be very good at interpretation of law. You need to be very good at, you need to have a certain kind of arguing skills, right? Right. So if we can go back a bit.
There was this slide.
So, right. So it helps to open your mind to consider aspects that you may otherwise miss or may not be even aware of. if you're preparing a brief or arguing in the Supreme Court. So that much is there. I told you which are those aspects. Many of the senior advocates may have, most of the senior advocates, and we'll see that, have never practiced in trial courts, right? But they have their own set of strengths that helps them to get the kind of fees they get, right?
So is it okay then that we're not having a trial court experience is fine, you're saying, if you want to start?
I'm not saying fine, just feel the experience. Just look at the senior advocates. None of them have a trial court experience.
Okay.
If it was so necessary to have a successful practice, why don't we have more trial court lawyers having a successful practice in Supreme Court?
Got it. So that's a very important point. So if there's a trial court lawyer, that trial court lawyer can also do some work at the Supreme Court, plus in parallel, somebody can just start a Supreme Court practice, not worry about trial advocacy and all of that, right?
Right. In fact, if we'll come to that point as well. Most of them get to know about these intricacies only. So now senior advocate is being briefed. So he's being briefed that this is what happened at the trial stage, this is what happened at the appeal stage. So he gets to know all of that, and then he gets to use his own skills to give it a twist and argue before the Supreme Court. That's what a senior advocate does. So quality of briefing definitely has an impact. Let's go to the next slide. When you are young and still building up a practice in the Supreme Court, you can take trial court matters as well. So this is something, since we are doing it for you, for people who are just out of college, or you are a law student, you're young, you have just started your practice. Therefore, this is one of the career paths you can take. So while practicing in the Supreme Court, you can also take trial court matters. That's possible. And I'll tell you how that helps. Okay. To be a Supreme Court lawyer, 100% of your matters need not be listed at Supreme Court, right? You are doing arbitrations, tribunals, trial courts, high courts, all of that. So being in Delhi, it's because there's so many arbitrations that keep happening in Delhi, right? Right, we can move. Most Supreme Court lawyers also get to do high court matters also. They keep arguing in Delhi High Court. And they have very, very important matters in high courts too. If a client, can we go to the previous slide? I couldn't see what it said. Yeah, clients are happy to be able to get a Supreme Court lawyer to argue their matter, right? Therefore, they are sought after. Next slide, please. If a client wants a trial court lawyer and you can go all the way up to the Supreme Court, guess who will they prefer? So basically, if a client comes has a trial court matter and he's getting a Supreme Court lawyer to do a trial court matter, obviously he'll prefer the Supreme Court lawyer if he's agreeing. Right? That's how you build up a practice.
If they negotiate fees with the lawyers, guess who will be with the other lawyer and with you? Guess who will be able to hold their fees better? Right? These are like self-answerable questions.
Is it necessary to be in Delhi to have a Supreme Court practice? No, it's not necessary to be in Delhi. Why? But why would a client pay for your? Yeah. So now if it's not necessary, okay. So why would a client pay for your travel and accommodation and let you argue before the Supreme Court rather than engage a Delhi-based lawyer who has been arguing before the Supreme Court? So suppose you have a Supreme Court matter and you are based elsewhere, and we are saying that you can still build a practice. But for that, your client needs to pay you for your accommodation, for your travel in Delhi. Why would they do that? For that, you need to acquire that kind of skills, right? Why would
you need to take the matter right from the trial to the Supreme Court, so they don't want to separately brief a Supreme Court lawyer on the matter because they already trust you.
That's right. That's one of the aspects. And still, they would also want to save money. So you need to have that kind. You need to be able to demonstrate that kind of skills also, that you will be able to handle their Supreme Court matters. You need to demonstrate that kind of knowledge also about the practice and procedure of the Supreme Court. You need to be able to say, even when arguing on charge, that Supreme Court mein to this won't work, 𝘮𝘢𝘅𝘅𝘅. So because Supreme Court will say this and they'll say. So you know all this only when you have an idea of Supreme Court practice, right? Yeah. What can you tell them or do to ensure that they can have confidence in you, that you can handle their matter in the Supreme Court?
Also, one more question. Can they, now virtual hearings are possible, so they won't need to travel, right? Until
that's
it's
right. So
physical
that's
hearing becomes a norm.
Mr. Mistry plans to cover, But yeah, this is a very interesting development that's happening. Let's see if it goes, like we'll see what happens in the near future. Okay. What can you tell? And this is fine. Next slide, please. For that, you need to be good at what we told you before, right? So do you always need to argue before the Supreme Court to have a successful Supreme Court practice? So some people may have that question in mind, oh, my rhetoric skills are not that good. Because when you go to Supreme Court, you realize everyone is arguing so well. So is it necessary that you always need to argue? No, it's not. It's not necessary. You don't have to argue.
Abhishek, can you get somebody to answer questions, or you answer directly? Okay. There are some questions you can take.
So what are the various ways of setting up a Supreme Court practice?
For newcomers, okay? This is for newcomers.
Yeah, so you can either start working with an advocate on record. This is when you don't have the experience to sit for the AOR exam. Yeah, next slide, please. Here you will master drafting, filing, briefing a senior advocate, and you also get to do some argument-related work. The senior will ask you to appear before the registrar's court. Only junior advocates do that. Seniors don't have time for it. Or you will be asked to go to the registry to sort any filing-related issue. So you get to learn these things there itself. You start arguing at this stage itself. And you can also work with the senior advocate. We'll come to the point whether you should start working with the senior advocate as a fresher or not. But this is one of the career paths you can have, right? You can also draft independent matters when you're working with an AOR, you cannot. But when you're working with the seniors do allow you, and you can do that. And you can get it filed through an AOR because it's mandatory for an AOR.
So if you start working from the beginning with a senior without knowing the drafting work, you will not be able to do independent filing at the Supreme Court. However, if you learn this separately and then you choose to work with a senior advocate, you can do independent drafting work, and you can have an advocate on record sign the matter, sign the petition till the time you qualify for the AOR exam yourself.
Right, and you can start if you are planning to be an arguing counsel, or if you would want to file and argue cases, then you can start arguing cases now itself. That's important to start at this stage. There are many juniors Abhyuday who continue to be juniors, and even judges are very, these days they start agonizing that, when will you guys start your independent practice? So it's important to start. Right, so after 5 years, after 4+1 years, you can appear for the AOR exam. You can continue to argue cases whether or not you file them. So by this time, you get to do that kind of networking that you start getting cases. You can even be briefed. We look at the profile of some of the senior advocates and see how their career trajectories went and what the current judges of the Supreme Court, how they started doing it. We'll look at it in a while.
There's a separate session on how to crack the AOR exam, which we're conducting on 9th. You can stay tuned and wait for that. But just stay with this right now, okay? First think of setting up a practice, then we'll think of AOR exam. Don't jump, please don't jump, guys.
Right, so we'll also have Mr. Mistry to speak on it in a while. I just forgot to contact him. I'll just do that. So
sure, no worries.
Yeah. Right, we can go ahead. Right, let's we'll just
Jamshid sir has joined, yeah. Sanchita, please.
Is he unmuted?
Yes.
Yes.
Hello, sir, how are you?
I'm actually recovering from a surgery, but I'm fine.
Thank you for joining us, sir.
Yeah. So if you could tell us about your experience of being in High Court and in Bombay High Court, and yet continuing to come to Supreme Court, and in various roles and responsibilities. We'll be more interested to know what were your roles during those matters. Yeah.
Sure. So, I mean, just to give you a brief background, I had started my career basically as, in the labor and service, laws. And my senior was is also he continues. I've only had one senior through my life, and that's also a good thing to do. I think it makes a lot of sense. You should be you should run a one-horse race if possible. Don't sort of they say Rolling Stones gather no moss, but I think if you have one senior and you're lucky enough and he can give you the right guidance, and I'm sure he has given me the right guidance. So we did a lot of trial work to begin with. That means going to the labor court tribunals and things like that, and then to the High Court, because all the appeals came to the Bombay High Court. And I think starting probably 1998 onwards, I remember my first trip to the Supreme Court, and that was very interesting. I got briefed on behalf of a peon, a lady actually, who was a peon with in one of the municipal corporation schools, and obviously she didn't have the money, etc. So what did I do? So I contacted a colleague who had sort of, when I was in a law firm, who had sort of, he had interned and I had interned as well. And I asked him, I said, this is the case, and would you like to, be the advocate on record? And he said, yes, certainly, why not? So we exchanged, we sent a draft affidavit in reply and things like that. And we finalized it and got it filed. And then on the day, so what I did, and I'm especially as an outstation lawyer, I must say this. I traveled to Delhi by train, okay, and got off at, I think, Nizamuddin, then took a rickshaw, went to the place that I was staying. Again in the morning, got up, took a rickshaw, went to the Supreme Court, and argued. And I remember at that time, I forget who the judge, I think Justice Shah, he was Chief Justice of Bombay High Court, and then he came straight to our affidavit and pointed out, and he asked the lawyer appearing on the corporation, what do you have to say about this? They had no answer, and the corporation's case was dismissed, and this lady was reinstated with full back wages.
So this was your first case, very interesting case.
Yes.
But tell me, what were the different? So you kept coming here, and there were cases.
Yes, sure. No, so that it's Supreme Court grows on you. Okay. Then I was briefed on behalf. We had this massive problem in Bombay, Mumbai, for the hawking and non-hawking zone cases. So you had every conceivable senior advocate in the Supreme Court on the side of the hawkers. Very few, for the residents, and also just a couple of them on behalf of for the restaurant owners and things like that. And it reached final hearing stage very, very quickly, and then it was this other, like I'll compare it to cricket. So the admission days, that is the Monday and the Friday, is like your T20 game, while the the final hearings, which is usually Tuesday, Wednesday, Thursday, is like a test match. So you have to be prepared for that, and that's very interesting. And Supreme Court is very unique. The practice is very unique in that sense. So filing written submissions, getting ready for each day.
So did you find it difficult coming from Bombay High Court to adapt to this practice, or how was it?
Well, fortunately, no. We had at that time several very, very good, Bombay High Court lawyers and even judges whom we were familiar with, that's the other good thing. Yes, the first time you go to the Supreme Court, you're awestruck. You're saying, "Oh wow, such large courtrooms, and very quiet. People don't make noise and things like that." And it was almost like, and those days they had refurbished it. I don't know whether they've done it after that, but it was plush seats and quiet, and always you kept in mind that this is the top court of the land. So whatever you say, you're going to make make history. And I'll let me give you an example, very interesting example actually. I was standing outside the Supreme Court, and one young lawyer was actually arguing. I mean, not that I was any sort of too much older than him, but I found that he was arguing a case about in relation to a motor accident claim. And I had argued a similar case in Bombay just a few days ago. Okay. And in the lunch break, we happened to be standing outside. And I just told him, I said, you know what? I think you should consider this. I said, I argued this a couple of days ago in a review petition in Bombay. He said, oh, wow. I mean, can you share me? So I shared the details, and, I just gave it to him. And I
Right.
believe
So it
he's
kind
succeeded.
of helps. So there is a connection. So even if you're practicing in High Court, it's possible to have
so Bombay High Court,
and
sorry.
And work on important matters like you. I mean, you have appeared in some leading matters in the Supreme Court, even though you have a.
Absolutely. No. Then, of course,
Right.
from.
So what about the virtual hearing now, whether it will go into a hybrid system? So what do you think? Yeah.
So I think, see, the virtual system it's very, very interesting. I mean, what we have seen so far, okay, is I mean, it's not the ideal system. I know the Supreme Court committee is working on it, and I'm sure in a couple of
Do you think it's really good for outstation lawyers to have virtual hearing, or do you think?
Absolutely. I mean, think about it. I mean, today, look at what Mr. 𝘸𝘀𝗃𝗃 is doing. He's appearing from London every single day. So why is it? And this is very good. Also, see, there is merit on both ends. People say, being in a physical courtroom is the atmosphere is different, etc.
Right.
Yes.
I think that's something that's not within the purview. Unfortunately, we would have liked to hear you a lot
let
more.
Me tell you.
Thanks for joining us. Thank you so much. Thank you. Yes. So let's go back to our presentation. Hope it was useful. I just brought him on board so that you realize that how a Bombay High Court lawyer has handled some of the very leading cases in the Supreme Court. In fact, he was involved even in the 𝘱𝘢𝘀𝘃 case, the one that relates to transcription of court proceedings. Right? We can go ahead. Yeah, so coming to a good question, I think some of you have been asking in the chat how to start working with the senior, what to do, etc. So we are going step by step. We'll be talking about how to start working with the senior as well, how to get into a senior's chamber. But before that, let's start with when should you start practice? So we are just on that point. Is it too early? Because some of you have that concern. You still have that concern. So let's see if it's too early. When should I start my practice at the Supreme Court? Would it help if I start early, or should there be a step-by-step process? So let's see the pros and cons. Okay, next. Different stages of career when lawyers start Supreme Court practice. Let's go to the next slide. So there can be different stages, right? So you can start your career either as a junior to an advocate on record, or as a junior to a senior advocate right after college. There's so many juniors who have joined AORs and senior advocates right after college. Let's go to the next slide. So you can also be, you start as a junior to any other advocate who does Supreme Court matters. If you're interested in corporate law, for example, you just today and a few days back, there was this lawyer who has been briefing us. He does a lot of NCLAT matters, and he has been briefing us on every alternate day for a Supreme Court matter. How? Because those NCLAT matters didn't come to the Supreme Court. So you can work in one such law firm as well, or with any such lawyer as well. No problem. You can start from there as well. Or you also have independent practitioners who brief lawyers for Supreme Court matters, right? Can you go to the next slide? Lawyers who clear AOR exam and build a practice in Supreme Court after practicing in other courts. Next slide, please. Then you have in-house counsels of companies who have dealt with matters before Supreme Court for their companies, right? Okay. Then you have retired judges. So these are the various points where people enter Supreme Court, right? So it's never too late and it's never too early. That's why I showed you this trajectory, because there are students who join in right after college, and then there are retired judges also, right? And then there can be other retired professionals. I've seen somebody who was in CBI, or even Abhyuday's dad, right? So even they join after. So these are the various trajectories. I really wanted to point this out before making a case for. So whenever you start to practice in the Supreme Court, it would take you a while to get used to it, to get better at it, right? So that's the point. That's the point. If you're a drafting counsel, lawyers would need to know you're good at what you do. So that's the reason why it takes a while. So whether you start your practice from trial court or you start your practice straight away from Supreme Court, when you come to Supreme Court, it's going to take a while for you to set up your practice in the Supreme Court, and then for it to get to be successful. I mean, it will take a while for you to be successful in the Supreme Court, right? So people need to know that, oh, this person is good for drafting, therefore I need to go. If you're an arguing counsel, again, lawyers would trust you only with the matters if they have proven if you have been able to prove your worth, right? So it takes a while. It takes a while, and therefore it's better to start early. You don't get to do that in every matter, and therefore it takes a while, because in some matters you'll argue and you'll get noticed. You may get a few matters, and then after a while you can again get some important matter where you get to show what you have got. So you'll need some time irrespective of whether you start to practice in the Supreme Court or whether you start at trial court level. So therefore, the sooner you start, the more time you have, the more time you can give to yourself, and the more time you can give to build up a successful practice. Yeah, the judges will also be encouraging and lenient. That's an advantage if you're junior. When I say junior, I mean in terms of age, then judges are way more encouraging, and therefore it's easier to start arguing. And therefore I said that you should start arguing early. Yeah. So you should aim at not just starting your practice early, but Abhyuday, can you go to the next slide? But to start arguing as early as possible. That's the point I was trying to make. For that, you'll need some years of experience of working with an AOR or a senior advocate to get a firm grounding in the Supreme Court, and only then that transition will happen. So again, if you're working in trial court, high court, that does not act as a substitute for your training in the Supreme Court. You will need to work with an AOR or a senior advocate, or it will be very hard for you to, get a firm grounding. Let's look at the career trajectories of some of the sitting judges. This can be interesting.
Should I open the links?
Please.
1 second.
I just want to show you how they became Supreme Court.
Stay tuned, everybody. I'm just exiting the presentation mode and showing you the links. Okay, now it'll work. So how many of you are enjoying this? Write E if you're enjoying. I'll have a question answer round in a bit. I will have, okay? We're trying our best to write the answers in chat. A lot of you are not writing questions in chat. Please write the questions in chat. What we can answer, we will, okay?
Yeah,
Okay,
first, let's see the Chief Justice and judges. Yeah, the other one.
Other one?
Yeah. Right. So let's see who got elevated, who was a senior advocate before. Go down, please. Justice Nariman, let's open his profile first. Let's see where did he start from. So he was made a senior counsel by CJI, so he practiced maritime law in New York, and then he was elevated to the Supreme Court after being designated as a senior lawyer, right? So no trial court practice. Let's look at Justice Lalit. Next, Justice UU Lalit. And it's interesting when you look at Justice UU Lalit's profile. He was enrolled in 83, practiced in Bombay High Court till 85. In somewhere in 90s, he became an AOR, okay? And he shifted his practice to Delhi in 86, right? And even after becoming an AOR, he had established himself as an arguing counsel, such that people were briefing him on matters in which he had not done the filing, right? So that's what, and he was appointed special PP for CBI to conduct trial in all 2G matters, and he was not at trial. He didn't have experience of that. That's what I wanted to show.
Wow, super insightful, right?
You have other examples. You have Justice Goyal, you have Justice 𝘗𝘁𝘳 Mishra. They all were AORs. They didn't have a trial, right? Justice Indu Malhotra, can we also see Justice Indu? Go down, please. Yeah. Right. So she became an AOR, and then basically she was arguing. She was designated as a senior advocate, and she started arguing. 83, she was enrolled. 88, she became an AOR, designated as a senior advocate in 2007. That's the trial. No trial. That's it. Because you need that much of time, even as a senior advocate, for your work to be recognized. I mean, she was appearing every day in so many matters. That's how you get recognized. That's it. I think we are in the AOR list.
Yeah.
Yeah, I think this is fine. I was just trying to show when Justice Lalit became an AOR. If you can just do Control F. And so Umesh Lalit. Yeah, 92 he became an AOR, right? And they designated as a senior advocate in 2004.
12 years after that.
Yeah, and he continued to be an arguing counsel along with being an AOR. That's it. I think I have fairly made that point.
So those of you who want to make long-term plans, you can calculate 5 years to be AOR, and then 12 years to be senior counsel, and then another 12 years to be, or 10 years to be a judge if you want to. Okay, that's one of the routes that can be followed. Everybody obviously doesn't get the same results, but that's something you can look at. Okay, you want to study somebody's career, then that's how you look at things. Okay, we'll proceed.
Otherwise, there's no chance. If you spend 10 years in some other court and don't even move to Supreme Court, then there's no chance. Right? At present, there are only 2,777 AORs in the Supreme Court. I'm one of them. Do you know how many advocates have been designated as senior advocates by the Supreme Court till date? Any guesses? I want people to guess this. No? 5,000? Oh my God.
1,400, 250, 5,400, 10,000.
10,000, wow. Let's go to the next
400.
400 is closer. 416. Oh, you have attended yesterday's session. This is cheating. Let's go to the next slide. Lokendra remembers it. I'm very proud of you. 416 total senior advocates. So who are the rest? So you saw 2,777 AORs, 416 senior advocates. So who are the rest of the advocates you see in the crowded corridors of the Supreme Court? Right? Next slide, please. They're either juniors of AORs and senior advocates or other arguing counsels, or even briefing counsels who travel from another state, just like Mr. He would have briefed some senior advocate, or he would have argued himself. There are counsels who travel from other states and brief arguing counsels in the Supreme Court or argue it themselves, right? Or you have an opportunity there, even if you do not have many arguing counsels from your state coming and arguing it here, but you have that opportunity. You can create that for yourself if you know how Supreme Court works. Right.
Okay. Yeah. What?
Many of these arguing counsels in the Supreme Court, they aspire to be senior advocates. So I told you, they're just 2,777. So there must be other arguing counsels. So why are they not becoming an AOR? I'm just trying to show you all sorts of career paths you have. So there are advocates who do not aspire to become AORs. So that's not the only route. There are some advocates who aspire to become senior advocates and they think they can continue to argue matters and they can be designated as senior advocates. Can we look at this page, please?
Yeah.
Yeah, can we open guidelines? Sorry, list of senior advocates first.
This one?
Yeah.
2019?
Yeah. This is the latest.
Okay. So how do we obtain insights from this? This is the total list.
So where's the list?
Oh, I'm so sorry. 1 second, it popped out in a new window.
I was thinking you asking me to first explain and then you'll show.
No, it opened in a new window. I'll just pull it here.
Okay.
On the side, it's opening on the new window by default.
Okay.
Now it's fine?
Yeah, perfect. So if you can do Control F, advocate on record. So in the remarks, you'll see it has to be hyphenated. Yeah. So there are 29 advocates on record in this list of 416 people, right? 29 advocates on record. Rest are, and just do advocate.
Okay. It will still show everyone.
Yeah. So total 137 advocates, out of which only 29 are advocate on records. Rest of them are just advocates, which means they all are arguing counsels who were designated as senior advocates.
So they are not advocates on record, they are not senior advocates, but they are arguing counsels.
They are arguing counsels who were designated as senior advocates.
Yeah.
Because I'll tell you why there is more chance of becoming a senior. If we can go to the guidelines now.
Okay, guidelines.
Senior advocates.
On that link, no?
Guidelines. Number 3.
Okay.
Number 3, yeah.
Again, it popped outside. 1 second.
It's okay.
So is this helping you? A lot of you have questions. So Nitish has been requesting that we do a question answer round. A lot of important questions are there. So I will do that, okay? And then we'll go forward. We'll do a small 10-minute or 15-minute question answer round after this, okay?
Yeah. Next page, please.
Sorry?
Next page. Page 2. Yeah, so you need to have 10 years combined standing as an advocate, or you need to be a judge. Next page, please. What is important, what I'm trying to show here is, next page. Yeah, so judgments, number 2, just see number 2, judgments which indicate the legal formulations advanced by the advocate concerned in the course of the proceedings. So in order to have judgments that would indicate your legal formulations, there's more chance that an arguing counsel will have it. There's more chance that an arguing counsel will be noticed. And therefore, Justice Meghal Lalit, even though he was a newer, he was also building up a practice as an arguing counsel, which would have helped.
Look at this, the subjects are pretty interesting. It's not just constitutional law, there's arbitration, there's corporate law, there's human rights, there's family law, public interest litigation, international law, law relating to women, specific topics. So very helpful.
Yeah, Justice Nariman, Justice Indu Malhotra used to answer issues to do a lot of arbitration cases.
I just need a moment's break and we can then do the question answer on.
Yeah, sure.
Okay. You could explain this point and I'll just be back.
Okay. Right. Why do people still say that they should first learn district court and high court practice first? Right? People still say that. We're again going back to the same question because some of you will still have that doubt in mind. How many of you still have that doubt? That if right. So that's why we are again going back and trying to see why do people still say it, right? Right, because there's so many lawyers who come to practice. You read a notification that made mandatory. Well, that notification, there was a resolution passed, and then there was also BCI's this thing. It tried to amend its rules, but there was a stay on it. So it's not in effect yet. But yes, some people have been trying to push it. But the point is, there is no hierarchy there, you know. I mean, there is difference there. You need different skill sets, but as such, there's no hierarchy. It's not like you need superior skills to practice in the Supreme Court. and there's some sort of inferior skills that's required in High Court, right? Right? So therefore, it's important to understand that you need different skill sets and there's no hierarchy. First, you need to understand this. And you need to say this to people who say that to you, right? Yeah, perfect. So, no, you're not going to get my phone number. Let me make that clear. I've been getting that request. Okay.
Guys, it's very easy to say, okay, how do I connect with AORs? Give me somebody's contact, give me someone's network, give me somebody's phone number. How is it going to help you? You want to build a career and now you want just to call and take free insights. That will not teach you what you need to learn. You have to put in the work also. Na? We are telling you a systematic way to do that. Please stay with us on that, okay?
So why do people say that? That's because some lawyers do not have adequate understanding of practice and procedure and etiquette as well when they come to argue before the Supreme Court. That's the reason. That's the reason when a lawyer who does not have an adequate understanding comes to argue, the judge says, oh, are you, and this has happened actually, are you thesis are you? So that will happen. Can we move on to the next slide? When such lawyers come to argue for a matter, they obviously leave a bad impression, right? And judges and lawyers in the Supreme Court are not used to seeing such. You see, it's all more or less perfect, right? Everyone's on time, everything is happening in order, etc. So they're not used to it. It's like this. This will happen even if a lawyer having many years of practice in Supreme Court goes to Supreme Court all of a sudden to argue a matter with no idea about the practice, with no idea about how to argue, etc. So it will be the same, right? So if you required a practice in the district court or high court to practice in the Supreme Court, don't you think that would be a requirement for becoming an AOR? That's not the requirement. What's the requirement? 4 years of experience in any court and 1 year of experience of training under any AOR. That's it. Yeah. Next slide, please.
Okay, so there are a few central questions that people have. Okay, I want to take, can we take some of those?
Sure, please.
1 or 2 questions are there out. If I'm a student in, let's say Bangalore or another city, or I'm in Assam or Northeast, anywhere, okay, but I'm not in Delhi. Now, how do I actually get started on connecting with AORs or seniors? Okay, that is one question. You want to take that?
Right. So one way of doing it is first you find a way. It can be that someone from your college is practicing in the Supreme Court. That can be a way to get connected. The other way can be that you yourself find email IDs. You can find it online, right? The email IDs where you can apply for internships. That's another way. Once you are there, once you get an internship anywhere, once you're in Delhi, and this is done by most of the students who come for internships, right? So they find out already where lectures are going on and where you can meet more people. They approach the seniors there, they participate in discussions there. There's a possibility of having an informal session with them, etc. Right? It can also be inside the Supreme Court, on the corridor, in SCBA canteen, etc. So these are the various ways of approaching. If you're not here in Delhi, then you just need to work a little harder when you come here. Yeah.
One simple way is this, okay? You have to know, if you want to work with an AOR and you all agreed earlier that they'll not train you, then what do you need to do? You need to go and train. Okay, so there are steps to this. Step 1 is learn the work that the AOR does so that when you go to their office or when you reach out to them, you can help them. Second thing is that you will need to meet the AORs, right? It's not so difficult. You just saw the list of designated senior counsels, right? It's not so difficult to find the person. It's difficult to establish your trust with them. Okay, now you can start building, you can start writing articles on how to draft and go about drafting Supreme Court petitions. You can start sharing that with Supreme Court lawyers. That they will be easy to find on LinkedIn. Okay. Separately, those of you who want to take our help, our placement team has already placed lots of students, law students, with advocates on record, and they've got great feedback from non-advocates on record litigators also and advocates on record also. Okay, and these law students aren't based in Delhi. Okay, I'll give you numbers at the end. Okay, but there are law students who've interned, who are not in Delhi, who've interned with AORs and done well during lockdown time also, and in 2020, post-lockdown also, in 2020 itself, Now we are in 2021. There's a lot more, people are doing a lot of more in-person work, but this has already happened. Okay, so this is one way. Another question that was being asked was that some of you were saying that how do I learn the drafting skills, right? A lot of you were asking, and what are the basics of drafting? So see, we wrote to you online, we wrote to you that you have to know a few specific things for Supreme Court related drafting. If you learn how to write a letter or you learn how to write a legal notice, do you think you can apply that to a Supreme Court matter? Do you think you can apply contract drafting skills to a Supreme Court matter? Do you think if you learn how to draft a criminal complaint or an FIR or a plaint, okay, in a civil suit, do you think you can do that in a Supreme Court matter? It won't, right? So it's going to be a different ball game, which is why it has to be specific. We tend to think that all drafting is one and the same, but it's not. It's actually forum specific. Every arbitration drafting is different. Supreme Court drafting is different. Tribunal drafting depends on the tribunal you're going to argue, you're going to present the matter in. All of that is different. Okay, Nitish, you want to ask a question, and you've been requesting a lot to be unmuted on audio. I'm making an exception. What, Sanchita?
Unmute him.
Yeah, I just do that. Everybody who had a question on drafting, are you clear about this? You all have been asking what are the basics of drafting, what you can learn. I will share the whole pathway with you. Okay, it can't be done in 5 minutes. Okay. Yeah, Nitish, you want to say?
Yes, sir. Very good evening, sir.
Yeah.
Sir, this is Nitish. I had my college from KIT University. I had practice with Mr. Ram Jethmalani when he was alive. Now he's in heaven. You must be knowing, sir. Sir, I want to ask that, sir, why, sir, directly we should start from Supreme Court? Why not from lower court, sir? Because, sir, as per Ram Jethmalani, sir, when we had internship, and I also worked with Legit Quest, I got Ram Jethmalani Excellency Award also, sir. He always said that we should always start from lower court, because that is the court where we actually, sir, learn how to draft cases. Cases are made, sir, in the lower courts, not in the high courts or Supreme Court, sir. So why directly from the Supreme Courts? If we are young generation lawyer, first generation or second generation lawyer, sir, then we need to know how the case has been started, the cross examination and everything, which is done in lower court, sir. That is not done in Supreme Court or high court, sir. Sir, then why actually not to start from lower court and directly from the Supreme Court, sir? This is my question.
So what did we say to you right now? We said to you that to be a Supreme Court lawyer, you don't have to do trial court work mandatorily. And sir, to do better at trial court, you can also learn Supreme Court.
Practicing lawyer, right?
Yes, ma'am.
Just give me one example where it would help you. You having cross-examined a person is going to help you draft any argument or come up with any argument that someone who does not have a practice in trial court won't come up with.
Ma'am, in the year 2020, I had my final degree, ma'am. Ma'am, I just started my training from the lower court, ma'am, because due to the corona, I didn't able to join several firms, ma'am, law firms, because, ma'am, due to the pandemic situation, I was not able to reach. Ma'am, so I started my practice
from trial court. See, Nitish, if you started from trial court, I'm not saying that you should leave everything and come to Supreme Court, because that's the only way. I'm not saying that. If you have started from trial court, that's fine. I'm not asking you to do something else.
Yeah, it's not mandatory that you have to start at Supreme Court. That's not what we are saying here. We are saying that can you start?
Yes, ma'am, I totally agree with you, ma'am. Ma'am, I totally agree with you, ma'am.
Simultaneously have a Supreme Court practice, right?
Yes, ma'am. Directly, ma'am, if we are directly having practice at Supreme Court, ma'am, we are missing this all parts of lower courts, ma'am. That is my point.
But you will always miss something.
And that's the point I'm making, and I'll keep making it till you get it, that you are not missing anything. Because at the Supreme Court level, all that the court is considering are questions of law. If you would have heard Justice Gowda the other day, we asked him specific questions. What do you look for in a draft? He said you need to draft the substantial questions of law properly. You need to know where your rights have been violated. You need to be able to formulate your grounds based on the correct legal position. Right?
That's for Supreme Court practice. Can I address something, Nitish? What you're trying to say is that, I'll not be a complete lawyer. I will miss out on something in litigation. So that argument has no end to it. But, when Senior Advocate Ram Jethmalani grows to Like His Eminence, he started as a trial court lawyer, and that's how he learned whole of lawyering. And
yes, sir. Actually,
that's
my
one way of
my
thinking.
point was actually, sir, my actually point was that we had conversation. I got opportunity
Yeah,
to
of
talk
course.
to him,
Yeah.
and that's why he shared his personal experience, and that's
Yeah,
why I
but
am
you tell
asking
me
this question.
something.
Nothing
You
else.
be a great litigator, okay? Some corporate law matter you will
Yes,
miss.
sir.
You may not know TD-SAT mein how work happens, or you may not know how
Sure.
work happens
Yes,
at
yes, yes.
N-class.
Arbitration matters.
Something or the other you're going to miss anyway. The only question is not key, what will make you a complete lawyer, because then you will have to live for 10 lifetimes to be a complete lawyer to know everything. And right now, the pace at which legal systems are evolving, no individual lawyer can keep pace with it. So what we have to identify is that what are the
We
things
are
that
always
we
a
can
learner.
work on. Correct,
Yes, sir.
exactly.
Yes,
So
sir.
now the point is that
Very
if I want to
fast.
build a good career, then what are the combinations that work? What can I start with? What things I can do in parallel? So we are saying two things: that one, you can start at Supreme Court directly and trial court experience does not matter. Second thing we are saying is that you can be a trial lawyer and learn Supreme Court work, and that will be fantastic. Third thing we are saying, you don't have to be based in Delhi to do any of this. Is that making
Okay, sir.
sense?
Okay, sir. Sure,
These
sir.
are the
I
3
will
points we are
be
making.
getting in touch with the mail, sir.
Okay, no
Okay,
problem.
sir. Okay,
As
sir.
a
I got your
personal
point, sir.
choice, you can choose to be a trial court lawyer first and then do Supreme Court. That is totally fine as a personal choice. Yeah, but
Yes,
if
sir.
you're a
Actually,
trial,
I actually wanted to practice in Supreme Court.
yeah.
I
So
got
what I
that,
would
and that's why I
Okay,
said
sir.
it's
Okay, sir.
okay if you have started with
exactly. So you can on the
I got
side
your anxiety.
learn Supreme Court work.
Ma'am, in the month of Feb end or in the month of March starting, ma'am, I will be in Delhi, ma'am. I will be starting from Supreme Court, ma'am. Kindly guide me up, ma'am, for the following other steps as per needed,
Sanchita is
ma'am.
conducting
Ma'am,
workshop
I'm taking long time.
webinars
Sorry
every
to take
day. She'll
long
guide
time.
you. Don't worry.
Other
Okay?
students are also waiting, ma'am.
We
Thanks a
will
lot,
continue
ma'am.
now. Okay. So you raised a very important point, Nitish, and I just hope that this was contributing to everybody who was there in the session. Okay, we
Sure,
move
sir.
ahead?
Sure, sir.
Yeah, thank you, Nitish. Then there was a question on Sagar. You need to repeat your question, and Abhishek, can you please actively answer questions?
Thank you.
Thank you.
Thank you so much.
Yeah.
Right. So we were at. So in order to become an AOR, there's no such requirement that you need to have a trial court practice or you need to have a high court practice. Right? It's all BCI which is coming up with resolutions, etc. But as of now, Supreme Court rules nowhere says that in order to be able to argue before the Supreme Court, you need to have practiced in district court or high court. No, it does not.
Sagar, we will help you. You are saying that no senior responded to you. Why did that happen? This is what we were saying when we started. Right? Sorry, Sanchita, just an interruption here. Sagar, why did that happen? You are again going down the entitlement line. Please catch yourselves, guys. You all are going down the entitlement line. You are saying that how do people like me, being a first generation lawyer, get an opportunity to work with? Good question, okay? With big legal luminaries and learn from them, okay? Good question. But when they are not even interested in giving people like me a chance to intern with them. Abhi, is this a question based on humane and charitable or fairness grounds, or is it a question based on skill grounds? Okay, I just want you to check that. Okay, and you tell me what the answer is. That will help you understand. When you want a chance to intern with them, what do you need to demonstrate? Is it about applying? Really? Is it just that I send an application and I need a fair chance? That's the question. Okay. Sarita, we've been answering this, but I'll re-explain. Okay, advocate on record is somebody who can file cases at the Supreme Court. You have to clear an exam to do that. You need 4 + 1 year of experience. There's a specific manner in which you need that experience. Senior advocate is somebody designated as a senior advocate. High courts and Supreme Court can designate advocates as senior advocates. Okay, they have criteria to do that. To argue in Supreme Court, you don't have to be an AOR or a senior counsel. Senior counsel means senior advocate. You can simply be a regular lawyer who can argue in court. To file matters, you will need an advocate on record to sign it. If you don't know Supreme Court drafting, they will have to also do the drafting for you. Okay, is that clear for everybody? Everybody in law school, everybody who's not very familiar with this, is this clear about advocate, arguing counsel, senior counsel, all of these terms? Okay, Ankush, last question. After this, we have to move ahead. Okay, all the stuff we're talking about is related to drafting. Okay, please don't disconnect the drafting as seeking, but this is all different. This is not different. Okay, Ankush, you want to copy paste your question again? Okay, so you all understood about the drafting part. Okay, I'm very happy about that. Okay, Abhishek will share his number so that you can reach out to him, Nishant. Yeah, Sanchita, please continue.
Right. So for an AOR exam, so they only ask you 4 + 1 years of experience, and you need to clear an exam. So the understanding would be that you need to know what they're asking you in the exam to become an AOR, right?
Yeah,
and what they ask you, right? So
we have a follow-up question. You complete this, then we will do. Yeah, please.
No, please do it.
After this, after the drafting part, we will tell them, okay? Because they're saying who to start with, AOR or senior counsel. So after you complete this part, we'll tell.
Yeah, okay. And I think we have a section on whether you should start with the senior advocate.
I think so, yeah. Please go ahead.
No, there is. I have written it. So there is. So practice and so you have these 4 papers in the AOR exam. Practice and procedure of the Supreme Court, you need to know that thoroughly in order to become an AOR. Even for an arguing counsel, that's the basic, right? Next is drafting. You don't just need to know the format. They don't ask you to write the format. They give you proper questions there and ask you to draft the petition. So they just check if you have the basic skills. But of course, to become a good advocate on record, you really, by that time, it means you need to have those skills, right? By the time you become an advocate on record, because on day 1, you will be getting matters and you'll have to draft, you'll have to prove yourself with every matter you get. Yeah, next slide, please. Then the 3rd paper is of professional ethics. Professional ethics, why is it necessary to know? Because it's not just about the soft skills you need to know when you're practicing in a certain court. Every court has its own etiquette, and which is very peculiar to it, right? So you need to know that. Along with that, you also need to know how not to get contempt notice issued against yourself. So for that, you also have to have that kind of understanding of the contempt law as it applies to a Supreme Court lawyer. The 4th paper is that of leading cases. There you don't just need to know the cases as they are in your textbooks. So you see it has a list of all the leading cases, right? But you don't just need to know what was laid down in that case, the way you read in your textbooks. No, that's not how they want you to understand the leading cases. They really want you to get it. They really want you to be able to interpret it. That's the leading cases paper. Okay, next. So this is all you need to be able to practice in the Supreme Court. You don't need to know how to cross-examine. Yeah, next slide, please. And you must have realized it has got nothing to do with district court practice. It has got nothing to do with high court practice. Supreme Court has its own distinct rules, right? Next slide, please. Why is it expected that you know all this before you file or argue a matter before the Supreme Court? As I was telling you, that you first have to clear this exam and only then you are allowed to file. Yeah. That's because lawyers and judges, and I told you this point as well. We can move on to the next slide. Right, most of the arguing counsels have been in the Supreme Court for a while. Next point, slide, please. But having said that, everyone has a first time. And therefore, when you go for an internship to Supreme Court, you may think, oh, I need to learn. I need to learn it elsewhere and then I can step into the space. No, you have to learn right there. You have to make mistakes or whatever. You have to, that is your battlefield. That is your playfield. You need to start there. Everyone has started there. Right? Next slide, please. The sooner it is, the more concession. I told you, judges are very encouraging when you're young. Otherwise, they start expecting a lot. Right, next slide, please. Next slide. Right, yeah, they do not want you to remain junior for a very long time. So that's why they encourage you to argue. Next slide, please. Most of the judges appreciate, yeah, this is something that even Justice Justice Gora was saying the other day, that he could appreciate, and you can see it on their faces, that they know it's because of the effort this council has made that the senior is able to make this point, or is so thorough because this council has briefed the senior, etc. Right. What was the previous slide?
1 second.
Right. Right. So how does one stand out? Next slide. So you would see there are so many freshers who get absorbed every year at the Supreme Court by advocate on record, senior advocates, law firms with matters in the Supreme Court. So how do you stand out? is the question. You always have an edge over others if you know how it works in the Supreme Court. Abhyuday, would you like to add something here? You were saying you wanted to add something.
For junior counsels.
Drafting, something related to drafting where you...
Yeah, so I have said that. Basically, you will need to have a full sense of the drafting work that is done by an advocate on record, at least. Okay, then you will need to know how to mention cases. You will need to know how to brief senior advocates. You will need to know how to do some small rounds of argument as and when it arises. Okay, so that is the part you need to learn. Okay, this is different from what you need to learn to do an effective trial. Okay, so we'll continue now.
Yeah, so next slide, please. Yes, so next slide. Yeah, so how will you stand out is the question, and that remains the question, because anybody can find out what the law is. They can research it, find out. Then how do you stand out, right? So just knowing the law will not be enough.
And wanting an opportunity based on a fairness claim is also not going to work. And you applying to more places than others is also not going to work, because your application has to be superior. Your skills have to be superior. Agreed with me till here? So where do you start?
Right, so we'll be looking at senior advocates, advocate on record, and some people also ask me about law clerkship. So we'll talk about all three and see where to start, which is the best place to start from. Yeah, let's start with the next slide, please. Do senior advocates hire freshers? That should be a first question, right? So let's, yes, some of them do hire freshers and pay them equally well. So that's another myth that people have, that senior advocates don't pay well, etc. But that's not the case. Should you start your career with a senior advocate?
One of the participants was asking that.
Yeah, in each workshop webinar, I get this question. Next slide, please. So this is my personal view. You should not, because I've seen freshers coming to a senior's office. It takes a longer time and they may never reach there. So some people were saying that, oh, you need to learn trial court work, but no, you need to learn drafting in the Supreme Court, drafting of petitions of the Supreme Court. And then if you start assisting senior, you will be more effective. And it's never that you'll go back again to a drafting chamber after working in a senior's office to learn drafting. So it's better if you learn from there and then you come. I think that's a path that most people follow and it works for them. So if you think you can get your own matters to draft while working in a senior's office, it would definitely be a good option. But again, even for that, you need to have already learned drafting. And drafting that's peculiar to the Supreme Court and the way it's done, firstly, the way it's done, the bare rules of it, and then to do it in a manner that stands out, that really works for you and for your client, right?
Tejal, you have learned already Supreme Court drafting. Won't we need to practice a lot of drafting to be great at it and valuable to a senior counsel even after you complete the course? You will learn enough to contribute right away. Okay, you are not valuable when the senior counsel is wasting their time to teach or spending time to teach from scratch. ये format होता है, ये होता है, this is how to write, this is how to frame an argument, this is how to put things together. When you go start having studied the facts and you prepare a first draft that they can edit, okay, the senior counsels won't edit your first draft, it will be an AOR editing. Okay, but if you get an independent client also and you prepare a first draft, then you go to your senior counsel and say, is this like the right kind of thing that I have written, the right line of argument? They will quickly see it and give you feedback because your draft is already in final shape. We are not telling you that you will learn broken drafting. You will be able to complete every petition that is heard in the Supreme Court. This is a course you can use to crack even AOR exam. Okay,
and
advocate on record.
If somebody already knows, I mean, as in is familiar with the format, etc. If you're here, you'll reach here with this course. And if you're here, so it will only hone your skills. That's for sure. And therefore, the first time you draft will be way, way better than otherwise.
I'll show you, okay? I'll show you some feedback that lawyers who get interns from LawSikho who are already trained and done some work, what do they say about our students who do that, okay? Yeah, you get to practice drafting in the course itself, and you get a week to do 2 drafts every week, and then you get feedback, you get inline corrections, you get extra coaching sessions. All of that is there. Okay, you get templates, study materials, live classes like this, so the whole aspect is taught. Okay.
Right. So that's another way of approaching it. If you already know how to draft, then you may not even start with an AOR, right? You can straight away join a senior's office, and then you start getting your own drafting matters. You start drafting. You already so you're getting both. Then you're getting the exposure to see how seniors deal with complex issues. And simultaneously you are collaborating with other lawyers, and you are already drafting matters, right? So it will help you in building your practice in future. You are a step ahead than others who have started with an AOR's office or are still learning how to do it, right? Yeah, so it definitely helps to get your own clients later on, because you've already started working. People have started knowing you because of the matters you're drafting. And you'll see in Supreme Court, they always write drawn by, filed by. It's not together. It's not just filed by. So you'll have your name there. Yeah. How much can you expect to get while working with an AOR or a senior advocate? Yeah. AORs can pay you. So
sorry, it exited.
Yeah, it's fine. So it's basically 20K to 50K. That's kind of average.
That's better than 5 to 20K or 5 to 10K at the high courts, which we were reading, right? So if you can get that, that's super.
Right. And then there are AORs who let you handle their trial court matters, and whatever appearance fee they're charging, they give it to you. So that's how you also learn how to do trial court matters. And let me give you an example of an arguing counsel who gets trial court matters, and she would give it to her junior because she has Supreme Court matters to handle. So that happens. Even as a junior, you get so much exposure when you're working with a senior Supreme Court advocate that no other court can give you. Yes, please.
Okay, 1 second. I need to navigate again because I have to reload the slide.
Okay, so senior advocate, some senior advocates pay you a lot. Mr. Salman Khurshid, Dr. Singhvi, Mr. Kapil Sibal, it's 1.5 to 2 lakhs per month.
Right? So if you were thinking that only corporate law pays, think again. If you were thinking that only working in a law firm is going to pay you, you got to think again. There are a lot of bright options if you are prepared to bag them. Somebody wanted to know this, right? How do you get into a senior chamber as a junior or as an intern?
So there's obviously no as such procedure. It's not as structured as law firms would be. There are various ways of getting into a seniors chamber, and nothing is good or bad. There's no such good way or bad way. And even if you are a first generation lawyer, please don't consider it as a handicap. It does not matter. There's so many first generation lawyers who are working with senior advocates, right? Including me. Yeah. So vacancies are never published, as you would know, but if they find a good lawyer, they can always hire you. So there will be never vacancies. You won't find a senior advocate except a few of them who I know them since a while, and it's been years. So they can tell me, oh, I'm looking for a junior. Otherwise, you won't even hear it in the corridors of the Supreme Court that the senior advocate is looking for a junior. But if they find somebody suitable, they'll always hire. Even if they have, say they can only have 4 juniors, they have never had 5 juniors. If they find somebody suitable, they'll hire them. They can hire them. Senior advocates do have that capacity to do it.
So imagine, okay, if I asked you that right on the SLP jurisdiction of Supreme Court under NCLT matters, which orders, which decisions of NCLAT should you go for SLP against, and then how should you make out your case? How should you create your case for that? Imagine you wrote like 10 articles only on this, and imagine then you checked all the Supreme Court judgments, okay, which are on IBC, and then you saw which lawyers argued. That is there even on Indian Qanun, Manupatra, SEC, everywhere. And then you wrote to them that, sir or ma'am, I have been studying these NCLT related work that you're doing. I know how to draft these SLPs. And this is what I've written. And these are 10 things I've written about working in the Supreme Court. And you might be from anywhere in the country. Do you think they will entertain that kind of request that I want to network, I want to know, I want to share my work with you, I want to have I want to apply for an internship in my next vacation? Will they agree with that? If you write like that versus writing just shoot off 20 applications and say, I want an opportunity to intern. They will, right, Lokendra? Yeah, because if you are actually showing that kind of value, you can do that with arbitration. Nobody has done that kind of analysis. You do arbitration case law analysis, but what about arbitration law practice at the Supreme Court, right? Swapnil will teach you how to start. You know now that you have to learn. The step 1 is learning, step 2 is placements and opportunities. So we'll give you the whole format and then you can choose how you want to go about it, right? And there's a lot of free webinars that Sanchita has done, and she will actually teach you all the drafting and practice work in the course with exercises. The entire system will be available to coach you and guide you.
Right. Internships. Some of you have asked how to get internships. You can apply via email. You'll always find a particular email where you will have to apply, right? You can't just randomly find any email and apply there, because most of these senior advocates have a separate email ID for accepting internship applications. If you apply it on their personal email ID, they'll never respond to it. They don't have so much time to respond to internship applications.
But if you've not got any value in your CV relevant to Supreme Court practice, that's where you'll get stuck.
Yeah. Next slide, please. Yeah, I told you informal setups, right? I already told.
I think even LinkedIn is like an informal setup if you use it properly. Obviously, keep professional boundaries. But if you do this work over time, 6 months you do this, I can guarantee you that if you're doing the work, you will get the internships that you want in Supreme Court.
Yeah, so you need to, so in order to be able to utilize those informal setups, you need to have that kind of knowledge. You need to have acquired or done something that you can talk about. If you think you can go and talk about how nice the tea is, that won't work. Actually, students think that will work. It never works, right? Recommendations. Okay, this is particularly for first generation lawyers and those who think, oh, we don't have any recommendation. How would it work for us, right? Many of you think that. First, let's see how many of you think that you don't have a recommendation, therefore you won't get an internship or you won't be hired by a senior advocate. Yeah, right. So I didn't have any either, right? So next slide, please. Some people did ask, how did I get into with Mr. So you can have family friend contacts that you don't have. I did have. Next slide, please. You can have work contacts. That's also recommendation. I have recommended people to work with senior advocates. You can have those. How do you get those contacts? It's not just by meeting them at parties. That's not how those kind of work contacts are created that will get you a job or that will get you an internship, right? What can those work contacts be like and how do you create them? Next slide, please. Yeah, so those work contacts can put in a good word. Next slide. Vouch for you. So you need, who will vouch for your work? Only the person who knows your work, who knows your worth, right? So you need to be able to demonstrate it wherever you go. So if you get an internship opportunity, you need to make full use of it. What happens is the moment students get an internship, they think it's done. Now they can put it on CV, it's done. It's not done. That's just a window. And you need to find your place. That's where you need to start working, right? You need to be able to show them that you know something. And so all the work that you need to do is before the internship to be able to demonstrate during the internship that you are worthy enough so that even if that chamber does not have a place, people working in that chamber can then refer you or can hire you later, just like in my case.
The big question on screen.
Right. What does an AOR or a senior advocate look for while hiring a junior? Senior advocate, now this we all know. Smart, confident, sharp, thinking on your feet, So you need to have that kind of okay.
So can you like imagine computer programming. Can you think out of your on your feet, out of the box, be sharp if you don't even know computer programming? Or you will need to have a programmer. First you have to learn programming, and then you have to like use both your out of the box skills and programming skills, right? Now if you say I'm just a very sharp thinker, I'm the best debater, I won parliamentary debate, I won model United Nations, I won so many moot court, now I'm very confident, smart, I can think on my feet. Senior advocate or advocate on record will confirm you? That is the question. So you have to know the Supreme Court work first. Okay. So what are the skills? Try to look at the Supreme Court rules. They'll tell you all the petitions that they have to file. Or I will show you the Supreme Court syllabus where I'll show you the petitions that are filed at the Supreme Court. You do that. Learn how to do that. Learn how to mention a matter in a court and learn how to brief senior counsels. Now, is this enough for you to know? This you know, right? Like as an information. Now, is it enough for you to apply and learn these? Then you'll say, how will I learn it? Right? So it will keep going on like that. So stay right now with the session, okay? Yes, Sanchita.
Yeah, next slide, please. Yeah, so you need to be able to demonstrate out of box thinking. Demonstrate is important. Just knowing it, having it in your head does not help. How does it translate into skill? So just reading a book in itself does not work. You need to know how to use it in practice, right? And that's where this course also helps to bridge anyway. Other factors that may work. So I'm also talking about the other factors that's going to work. Apart from your knowledge and skill demonstration, well-connected can get matters. So when you're working in a senior's chamber, they would look for a junior who can get matters to him, because a senior advocate, sorry?
Yeah, go ahead.
Because a senior advocate cannot directly deal with clients. Therefore, they would prefer that. Yes, please go ahead.
So what I think is that, the connection part is a function of having some confidence, and that comes from knowing the work. And then also building your network over a period of time. So once you have the confidence, then you take some activity of reaching out to people, talking to people. Because if you don't know anything about how you can help people, then you will not do your networking, and you will be like, oh, I have to just give my business card or I have to ask for work. That is very shallow level networking. But if I know something I can contribute, then I'll have more confidence. I'll meet people over a period of time. So when the time is there to help out somebody, or when I need to contribute to my senior, I will have some resources and connections to pull. Okay, that is what will matter. That is how you get that to that well-connected or can get matter stage.
Yeah, next. Belonging to the particular region from where the senior gets a lot of matters. Yeah, so this is also something you can look for when you're applying for internships.
You can basically, so they should look for seniors who have moved practice from their state high court into.
Abhyuday, sometimes these seniors keep getting matters from just that high court, or predominantly their matters are from that state. Then that helps. But many of the senior advocates, their practice has expanded in a manner that they get matters from everywhere. So you need to find out, and you need to do your own research and find out who are the advocates who were practicing in your high court, or who are being briefed frequently by advocates of your state. Then you approach them for internship, and then there will be a greater chance that you can get a degree.
So how will you find them out? I'm asking everybody who's participating in the session, how will you find out such lawyers? And I want you to give an answer which doesn't require you to be inside the premises of the Supreme Court. How will you find? There are lawyer searches available on Indian Qanun, on paid, like anything like a Manupatra will allow you to search by counsel. You can also search on Indian Qanun, which uses Google search engine only. So you search on Google, use Google only, and search inside Indian Qanun. Do a site search, write Orissa site /indianqanun.org. Write Orissa, for example, Supreme Court and lawyer, okay, or Supreme Court advocate Orissa, and then cite indianqanun.org. What you will find out is matters which came from Orissa. You will be able to find out some lawyers who are getting work from the state, from a particular state. Okay. Not by just dial. That will not help you.
And
Okay,
please
so
do not contact, don't find phone numbers and contact them.
yeah.
Next slide, please. Specialization area. Of course, if you are, if you have that, if you specialize in arbitration, say you gain a lot of knowledge and you can demonstrate, then of course, if somebody is doing a lot of arbitration matters, they will.
So arbitration, you want to work on arbitration at Supreme Court, then you'll find different lawyers. You may, okay. You want to work on IBC related matters at Supreme Court, it'll be different. Sometimes the same senior may do work under multiple laws that will totally differ. Okay,
we have some very good tax specialists in the Supreme Court. So if you, and it's very difficult to find a lawyer who is good in taxation, right? Therefore, when they find one, they would definitely hire you and they'll pay you enough. I know somebody who has a junior who's working with them since ever, and he's a retired High Court judge's grandson. He's still working with the same senior just because he's expert in that one subject matter. Go ahead. Right, so LLM degree, we're going to discuss that also, to what extent that will help you in practice, but in a senior's office, you'll find that, yeah, this is also one of the factors. Right. Next slide, please.
So people prefer LLM degree when, they can use it as an instance ki, chalo, you can work under some stress, you can do some research, you have a rigor in research and writing. That is something that counts. Or if the senior is from the same college, then also that will count.
I mean, I'll tell you something. What happens in a senior's office is you are being introduced quite often. Oh, she has also been to Harvard, or oh, my junior. It's like that. So it just helps them to introduce to clients, high-profile clients, etc. That, oh, we have good people around. That way. Right. So what should you look for in a senior advocate before applying for a job? Should you even look for anything? Some people think, oh, he's a senior advocate, should be enough, right? So let's look at that. We'll quickly go through these slides. I don't think this is something where we would want to spend. What kind of matters do they get? You need to look at that. If you find a job at a senior advocate's chamber who does all sorts of matters, and you find a lawyer who is doing high-profile matters, doing complex cases, then you obviously will prefer that, right? So that's how you.
Did you all capture the part that I was sharing about the kinds of matters? Did you all capture like SLP, statutory appeal? In some cases, there is original jurisdiction also, center state, interstate disputes, center state disputes. Are you all following this part? Could you register this?
I think at some stage we can go through the syllabus.
Sanchita, do you have the PPT to start? I'm just getting an urgent call.
Okay, so some AORs may be doing far more interesting, complex, high-profile matters than a senior advocate. If you get placed there, my question would be, would you still need to work with a senior advocate? No, you may skip that part, right? You may rather work at a law firm or with an AOR who does way more complex cases or deals with way more complex issues, right? So I told you this example, a law firm that keeps briefing. Whether they allow juniors to take up their own matters, this may be interesting because at some point you will start taking your own matters by working at the senior's office, and this helps. Next slide, please. Workload, of course, keep going. I think this we can cover first. Special temperament, working style, yeah, because you're working in direct, law officers, chambers. Law officers, who are the law officers? Attorney General, Solicitor General, Additional Solicitor General. These are the law officers, right? So it's very different from the nature of work will be very different. So you need to know that as well. At 7 p.m. you'll get this bundle of files to read for matters that are listed next morning. So you should be prepared for that if you join a law office. As compared to a senior advocate's office, it may be relatively easier to get into a AOR's office, but to be there and to continue to work there is a challenge, trust me. And AOR would want you to start drafting right after you join them. I think we've covered all these parts unless you want to add something. Right, quality of draft, I think Abhyuday, you told this. I told this, drawn by, filed by. Should you start working with a judge first? So we are done with senior advocates, AORs. Now there should be in the question, if I get into law clerkship, should I start from there? Law clerk come research assistants are engaged by Supreme Court in a short-term contract. It's a 1-year contract, and the remuneration is 65,000 per month. Next slide. If you're looking forward to a career in litigation, you need to know how judicial mind works, and therefore clerkship under a Supreme Court judge could be a good idea. You can observe some of the best legal minds at play when you're working with the judge, right? You get to read briefs. Judge will ask you, next slide, please. You start thinking what should be the approach. So this is something you need to do by yourself. Nobody is again training you here. You are just getting to read briefs. You will then be asked by the judge, okay, what is there in this case? But you need to do your own thinking and understand and anticipate what the judge will be thinking on it, and then compare. So if you're getting into a law clerkship, if you use it in this manner, then it's fruitful, otherwise it's submitted. Okay, so you, again, to appreciate this best, you need to understand the full cycle of the petition from filing to hearing. Only then you will be able to assist the judge properly. Obviously, you want to leave a good impression on him. And you also get to, you never know, you will again appear before him, or you'll get to do arbitration matters with him after he retires. So you never know.
Yeah,
Therefore,
and this,
yeah.
yeah. So this is a 1-year contractual clerkship, right? So after 1 year, you have to still figure out what to do. So you want to use that 1 year in the best way possible, because after that, you'll again have to go back to the traditional method that I want to be with a AOR or with a senior advocate. And now if you want to understand how the judge's mind works, you will need to know the whole case history, not just from the stage of filing at the Supreme Court, like what has happened before and how to actually take it forward, and what is the issue to be argued, to be understood and decided upon. Otherwise, you will not be able to follow. Like in my Supreme Court internship, when I couldn't follow. So many files were there. There was High Court order, there were SLP, there was counter to the SLP, and I didn't know like how to sift through the whole matter. I couldn't understand. Now, if you don't know the work also, you will do what? You will basically passively observe the judge. So you will learn some general stuff, but you will not exactly get the full benefit. Are you doing that 1 year internship or clerkship for the 65,000, or are you doing it because it's a good way to learn and set up your practice? If you're doing it for setting up your practice, you want to learn you want to know that, exactly how the judge's mind is working. So you want to be thinking on the same lines, literally eye to eye with them. So you have to do the best to match up to that level of thinking. Okay.
You something, qualifying for a race is not an achievement. It's only when you perform at the race, and the performance is dependent on the training. So it all goes back to your training before the race, and not what you do during the race, because that's really that will lead the path for future achievements and stuff, but ultimately it's the training that matters for all your future achievements. Yeah, there's a difference between courtcraft and public speaking skills. Do you agree? Yeah, tell me. Yeah, so I think somebody has to answer this question. Is there a difference between courtcraft and public speaking skills? Yeah.
Okay, so some of them are agreeing that there is.
There is. You can understand the full flow of proceedings only when you can connect the petitions with the interpretations. Right, I think we have covered all this part. We can go ahead. Yeah. Without knowing the strategy or the drafting, it was simply by observing the judges. I think we've covered all this.
It got stuck.
It's okay.
I'll go into presentation mode again. There was a keyboard shortcut that got pressed. Started now. So I was understanding the whole system. Like somebody asked that, law students, how will I do a clerkship? But that's not possible as a law student to do this. This is for law graduates. Now, what if you want to learn this as a law student? Yeah.
Right. So there are other ways of learning this. You can learn by observing. I was talking about how the judicial mind works. So you can learn by observing court proceedings, reading judgments on the issues relevant for your particular case, but you need to do it. Somebody needs to really guide you on how to read judgments. The other day I was having a conversation, the person was like, oh, we were made to read judgments in law school. It was of no use. But you need to know, somebody needs to train you how to read judgments so that you can put it to use when you come to practice, right? Yeah, so you won't get draft petitions during your clerkship. You need to learn it at some point. Yeah. Next slide, please. You may get to do exactly what you would be asked to do during internships, right? So this is something you need to keep in mind when you apply for clerkships, that this will be the nature of work and this is the maximum you can get from there. And therefore you need to start networking right when you are doing your clerkship, right? If you think, oh, I have got this, now I'm done, like my life is set, that's not how it works. Yeah, next slide, please. When you spend 1 year after college doing this, other classmates may be working on building their practice and then you'll be competing with them. Therefore, next slide. So even if you choose to opt for law clerkship, you should continue to focus on networking and you should keep planning what you will be doing next, because 1 year will pass just like that, right? You may also consider internships under High Court judges, senior advocates, right? Supreme Court judges as well. After all, it's these judges and advocates who make it to the Supreme Court. So even sometimes you can get like Justice Muralidhar, for example. I mean, he's amazing at it right now. So if you get somebody like that, I think doing an internship would be great. So you need to find that out as well. You get to learn a lot from their experience of arguing and deciding cases if they like to interact with the interns frequently. Next slide, please. Yeah, next slide. Keep going. Right. Keep going. Right, I think we've covered this. Right.
Yeah.
So you guys had already asked me questions and we've covered this. So you can get drafting assignments, and this is something you need to seek. So see, we won't know whether you know this, don't know this. So we will just ask you to do some research as an intern. But if you can show me, if you can tell me that, you know what, I want to draft this, I've drafted this earlier, or if you give me, I'll do it, right? So I will give you, right? Yeah, what you get to learn during internships, next slide. Not much. So this is important. During internships, again, the moment you get an internship with a senior advocate, you think, oh, I've got something, now my life is set. Right? So I want to keep telling you, your life is not set. When you don't learn much during internships by yourself, right? It will give you some exposure in terms of how things work in the Supreme Court, but you can always waste that time in the cafeteria having coffee and it's gone. Because you're thinking, oh, it's adding something to my CV and it's gone. All right, next slide, please. I want to think that you'll be trained, but that does not happen. So right now you all were asking me questions on how do I get into an internship, but just an internship will not take you there, right?
I know advocates on record who don't want to hire juniors. They're like, I'll do my work myself. Okay, once in a while I'll take an intern, but I don't want interns because it's too painful to deal with their work.
Yeah. I mean, if nobody's adding value to your work, then you don't want to have them. Right?
Okay.
Yeah.
So if you need...
Yeah, it's okay.
Yeah, okay. Now, how many of you are interested in figuring out how to learn this work? We have been saying, acha, training you won't get, then you should learn. How do you learn? Sanchita, where should I...
Yeah, so the moment your internship ends and you join, even if you join the same person, the person will then expect you to deliver. Then how do you deliver all of a sudden is the question. I think this is where you can start your... Yeah. LLM necessary? Is LLM necessary? I think some of you may have that question. So for litigation, it may not be that necessary, but if you are looking at, if you have the, can we go to the next slide? Having 2 more years of practical experience will be way more useful for you.
You want to pay 30 to 50 lakhs, then you pay on your education. But the thing is that you're trading that against real experience, which you can get. So which one you want to choose, that is going to be your call.
Would it help me in developing a Supreme Court practice if I have an LLM degree from abroad? This is in the question that people have. Yeah, it definitely leaves an impression on the client. This is for sure. When they see something in bracket, Harvard, Oxford, it leaves an impression. It's like, it makes it easier for your lawyer friends to talk about you, to refer you matters, etc. Because you've been networking with lawyers. They may know how good you are, but how do they show to the clients that you're worthy enough to handle the clients? So these small things can help for
This
them.
is the challenge here. That
Yeah.
how do they prove your ability to do the work? In Harvard LLM, they didn't teach you to do Supreme Court work.
Yeah.
So this is basic credibility, but basic credibility or LLB degree is also giving you, right? So it's not absolutely necessary.
Right. So you may have spent that 1 year in India building up your network or doing some smart lawyering that will perhaps get you more clients than spending it abroad. Right? So if you can, so if you get to work on some important matters during that 1 year, it's of course way more valuable than an LLM. However, you have to make a call within the first 2 years of practice. And I really want to make this clear because some of you may think you can go later on. Once you've set up a practice and have built a network, it will be very difficult for you to leave for a year, right? Next slide. Next slide. Right. Apart from leaving a good impression, this is at the most what an LLM from abroad does for you. It definitely helped me. That kind of exposure did help me. It does bring a certain degree of sophistication in your approach, but it's only when you use it properly, right? So many of the arguing counsels have been abroad, have got a good degree from abroad. And how does it help you? Of course, it helps you, but how do you utilize that 1 year there is what makes a difference. And we can talk more about it, but maybe that's for in the session to do what I did, etc. I can talk more. A degree doesn't do anything by itself. And I've seen people wasting that year there, thinking this degree will get them something. It does not. Right. If you're looking forward to a career in litigation, Supreme Court practice is a must. So you may not know trial court, high court, you can still work in Supreme Court, but if you are looking forward to even practicing in trial court and you learn Supreme Court practice, it's going to help you. Let's see how. Most of the law as it exists in the country is settled by the Supreme Court. If you don't know Supreme Court practice, you will struggle to differentiate Supreme Court cases at high court level, right? So you are obviously dealing with cases that have been decided by the Supreme Court, 141. So Article 141 gives a precedential value to Supreme Court judgments. Therefore, you'll hesitate to reach the Supreme Court because you will not know the rules and the principles, right? Therefore, it becomes very important to learn Supreme Court practice. Next slide. You will mix up issues of trial with issues of law, issues of facts with issues of law. Next slide. Learning Supreme Court practice gives you a better understanding on what can go wrong when you're handling the trial or the appellate stage, something that cannot be undone later. I think this is very important because if you're practicing, it makes you a better lawyer, because if you're practicing in trial court, you should be able to tell your client that this is wrong. What the judge is doing won't hold water when it goes to the Supreme Court. Something of that sort you need to know, or you need to know even backward. Like if you have been handling Supreme Court matters, you would see the blunders that have been committed in courts below that now cannot be undone. And therefore, you don't commit those blunders yourself when you're practicing in the trial court. What kind of resources? Next, go to networking. What is the difference between what kind of, so you will need different set of networking skills. Supreme Court. So you get cases from different parts of the country, from high courts. Next slide. So clients are bound to need another lawyer or set of lawyers in Supreme Court to handle their case. Mostly clients go to those who are referred by the lawyer handling their case in high court. So therefore, the point is that you need to have a good networking with lawyers of other high courts. Next slide.
And for the type of matters that you want to handle.
Right. Next slide. Next slide. Right. Next slide. Right. So if you have made your name as an arguing counsel, whether or not you are an AOR, you start getting to deal with cases pertaining to issues you have already argued successfully. So you see, automatically, you are starting to get in matters, you start to get matters pertaining to the issue that you have already dealt with. Skills. Drafting, quick, effective. Why quick? Next slide, please. Mostly they come at the last moment or after there's already been a delay. The clients may have spent a longer time to decide if they want to move the Supreme Court. They may have spent further time to come to you to decide which Supreme Court lawyer to go to, right? And how much time do you have to file an SLP? You have 90 days from the date of impeachment order if the certificate has been refused. So with time, you can acquire such mastery that nobody will be able to differentiate between a petition you drafted overnight or you have spent a week to draft. So that's an important skill you need to be able to draft quickly. That's something that you don't get time to learn in a drafting chamber. They expect you to do it immediately. They expect you to learn it and do over a draft, to prepare a draft overnight when you will need days. I think, Abhyuday, you moving the slides is not working for me.
You want to do that? You can load, I'll wait. You can do that, no? It's fine.
It's okay, let's do it. Yeah, so some lawyers can charge much because they, yeah, but I think it's done. I think we have discussed.
So I'll move then to the learning part, okay? How to get started with learning. Is that fine?
Yeah.
Okay. So I'm just checking. If you're not in Delhi, for example, what do you need to do to set up a basic practice in the Supreme Court? Learn the basic skills required for drafting a petition or appeal in the Supreme Court, whether you're in Delhi or outside Delhi. Know the different remedies to advise your client, because there'll be, before drafting work, you'll have to do some advisory work. What is the strategy to take? Because you can say, I charge this much for a draft, but the client says, I have not decided to file at the Supreme Court. So that's where your advice is important. Okay, what's next? You have to be drafted by you, or you can give it to somebody else, but you need to draft it ideally and then get the AOR to sign it. Okay, you can get it filed through an AOR, argue yourself, or brief a senior advocate. So if you've got your own client, you have the discretion to argue yourself if the client agrees. And a lot of times senior counsels will have a very high fee amount, because of which they will prefer sometimes that you may get chances to argue directly for your client's matter. Then nobody can stop you. You don't need to be an advocate on record to argue before the Supreme Court, right? But then to do it properly, you will need to know the practice and procedure followed. So you will need to know the jurisdiction, the powers of the Supreme Court in comparison, what point the Supreme Court will decide and at what point the matter will go back. Otherwise, you will write stuff in your draft that doesn't matter. Okay, then the knowledge of what works, what does not is important. You have to analyze the success chances of a client and clearly say, okay, this is where the tricky points are. This is what I will argue, right? Now, how can LawSikho help you? Okay, now before I go on to explain, so you all have said, no, okay, how will we learn? How will we learn? Simple way to learn is what? Somebody has to teach, right? So we'll help you through a course, but I am not going to talk about the course right now. First, understand why we're talking about this. Okay, successful lawyers are rich. Do you agree? They charge well to their clients. Clients pay them well, right? Now, young lawyers can earn well too, but that's not happening. What? Yeah, and without your earning being at the cost of learning. A lot of us say that I want to learn, I don't want to focus on earning, but still the learning doesn't happen properly. Okay, so why? Because you may not get the best kind of exposure you want. You may need to change, or you may need to shift your job. There may be personal reasons. You may need to shift states. You may need to shift employer. All of that keeps happening, right? So you need to be in a position where you can learn and earn, and you can learn independently, right? So I'm against the idea of charitable entitlement, where we say ki, I should get a chance. I've graduated, put in 5 years. I'm willing to work for so many hours a day. So why should I not get a job? Why should I not get a chance? What will you get the chance on when there is nothing to show on the record that you will be effective, right? So what do you want to do? It is difficult for a market to sustain. Like the whole economic system fails if you say, I want a chance. And what will you prove? You'll prove yourself by working hard, but what will you prove? How will you prove that you can do the work, right? So India doesn't offer that kind of social security regime that you will don't be employed, you will get this much allowance every month to run your cost. You don't have that in India, right? So why should a senior advocate or an advocate on record take that on their head, right? So they have to operate by market principles. Do you agree, 𝘠𝘢𝘅? They have to operate by market principles, right? Harshita, you should stay till the end. You will find this last part very helpful. Now, I want to say that, okay, now what have our students secured in the market? What are these market principles I'm saying? That how do our students, how have they done, well in the market? So more than 30 LawSikho students have secured internships under Supreme Court lawyers or advocates on record since March 2019. Okay. This was the worst time for litigators, but our students continue to work on their success. More than 5 jobs have been secured by LawSikho candidates in litigation. 2 out of them are under advocates on record. More than 40 internships in this January 2021 was secured in the area of litigation, various forums. Okay, more than 5 litigation internships. More than 5 students are getting stipend of 5,000 rupees or more. These are law students. Okay, more than 20 freelance client opportunities have been secured by LawSikho candidates. These are Supreme Court and High Court matters, several Supreme Court, High Court matters, several NCLT matters, RERA matters, many of these. Some recruiters who hire from us. Okay, I'm running through a list. Panel Counsel for Union of India, former civil servant, Supreme Court AOR, Sanchita herself has been taking interns. Okay. Gagan Gandhi, managing partner at Niti Nyaya Law Offices, Supreme Court of India. Can you see the names? They are at Supreme Court, either advocates on record or Supreme Court or senior counsels. Feedback from some of the litigators. So just read, okay. Ashraya Chaudhary, a student of LawSikho, interned in my chamber for a period of 1 month. I found him possessing appreciable industry-oriented practical skills like drafting. This is a panel counsel saying this, okay, and we have to take it as they've said it. We are not polishing it, right? His legal acumen and practical skills were exceptional for a 4th-year law student. Okay, Sudarshan and Prachi, who joined in November, were very dedicated and hardworking. Just look at this, okay? For general litigation or competition litigation, interns were hardworking, and thank you for providing us with this wonderful opportunity of working with these bright students. So people like it if somebody does a good job. LawSikho has been instrumental in recommending sincere, hardworking, and diligent students for internship and has contributed to the legal education. Okay, interns sent by LawSikho are far more efficient than the ones coming by reference. I really appreciated the work of 𝘠𝘩𝘢, as he was always enthusiastic to work and ask for regular feedback. Constitutional and criminal matters, okay, the litigator has been working on. What are the students saying? Okay, so they are talking about the internship. Now, why are they happy? Why are the recruiters happy? Because the match is there between what the student wants and what the recruiter wants. Okay, so like the intern is saying, I get a lot of new work, and initially my senior was apprehensive, but later seeing my work, he or she started giving me more work. I have translation of FIRs, filed a writ petition with reference to CAA and RC. In the Punjab High Court, filed grounds of appeal for a murder case, handled a customs matter. 3rd-year law student, okay, from criminal litigation course. How many of you want such kinds of opportunities? Yesterday, Tanveer Ahmed sir's office confirmed 2 interns. Okay, he represented the parents in the Arushi Talwar murder case. Okay, he is a hardcore criminal lawyer, very senior, very experienced. Okay, then
Sir, hello.
Yes, Abhishek.
The student that we had sent, they are in the 4th year. So it's like assessment internship if they will perform well.
Oh, great. Okay. So now Khyati Mehrotra, 5th-year ILS law college student. So what you should see, is there anyone from ILS law? What you should see is that, who is the person, which college they are from, which year they are in, and then you see that, what kind of work they've done. She drafted in SLP, researched on scope of Article 226. Okay, a lot of constitutional work, right? Now, how did they achieve this kind of success? What was it that helped them? So learning the work is not easy, but the opportunities are very promising. Okay, now you can get to a position, that's my belief, and that's happened, and you saw the feedback, right? You can get to a position where you can prepare a near final first draft. Okay, somebody asked that, after the courses, can I prepare such good drafts? I'm saying you can prepare near final first drafts. I don't know in a Keshav-Nanda Bharti type of case whether you can prepare a near final first draft, okay? But in a regular Supreme Court matter under any statute like arbitration, NCLT, any SLP that you're drafting, okay, a transfer petition, a review petition, all of these, or curative petition, an appeal, criminal appeal, these petitions, you can prepare a near final first draft, that I can assure you, okay? Now, your question should be, how can you achieve the success that all these students achieved, and why can't you reach newer heights? Why do you have to think of this, ki, acha, what can I do for free? And then where will I go? Then you will always keep saying, okay, can I go as much as these people went? Can I do as much? No, I'm saying do better. You can do much better. You can do it with training. We have seen law students file their own cases, file PILs. So law students, as a standard method, people file RTIs, consumer cases. Some have filed PILs, right? Shreya Singhal filed a PIL when she was in college, and she will be coming for one of the sessions. Now, the question is that law students can do this. So why not develop themselves further to do this, right? We have been training law students to draft contracts. We've been training them to get foreign paralegal work, and they can do how, like, they can learn how to draft Supreme Court petitions effectively. It's completely doable. Now, how do we teach you in that? Okay, so there is a course that we have launched. Sanchita is the key course resource person, external faculty. She has contributed like tons of her personal insights into it, okay? All her experiences, plus she will be inviting a lot of senior lawyers to take guest sessions in the courses. She has already started inviting a lot of senior lawyers in the webinars. You must have been seeing that, right? But how, what do you...
Supreme Court judges.
And Supreme Court judges, yes.
Retired.
And so now, sorry? Retired Supreme Court judges, yeah. Okay. So now, how do you actually learn about this? Do you want me to show you how the course works? I'll show you here, then I'll show you on the website. I'll show you on the website, okay, first. So you go to lawsikho.com/courses, very simple. Okay, this is to find out what you will learn, what is there in the course. This is a 6-month course. There'll be 2 classes in a week. Sanchita will actually give you all the insights on specific matters, how do you go about drafting, and she will give you, there will be 2 exercises every week that you will do. Basically 2 drafts per week you will make. People don't make this in a senior's chamber in 1 month of internship also. Okay, 2 drafts end to end per week. Yes, Sanchita.
So I'll tell you something. My objective would be not just to make you acquainted with how it's done. I won't stop there. So as I told you, if you're here, I'll take you here. That's my promise. Take it from me. I don't know if it will be what will you do if you have to draft something like Keshav-Nanda Bharti, but wherever you are now, you'll do way better job, and I'll push you enough so that you reach there and you're happy and contented with your draft, your own draft. I think that's something that's very important for anybody who drafts.
So this is what this is the course link. I am just sharing what you will get to learn. Okay, you will come to know about the petition. Those of you who have graduated or you want to sit for the AOR exam, you can use this to also attempt the Advocates on Record exam. She will teach you the whole syllabus for becoming an advocate on record, including your leading cases, professional ethics, all of that will be taught. Okay, I'm not going to go through the whole page. I'm going to share this part. Okay, on the left you can see you can see specific learning objectives. Okay, so you can see these. How to skim through an impugned order, how to mark what is facts, what is evidence, and then how to create the grounds, how to point out that the relevant aspects were not considered at High Court, how to distinguish question of law from facts. Okay, various other points you will see. Okay, how to identify research points, different kinds of research tools to use, how to approach your legal issue. Okay, what to cite, how much to cite, devising different strategies for different petitions, what to plead, how to prepare for hearings. Okay, how to brief a senior advocate, role play simulations. I'm just skimming through it. Okay, if you read through it, there'll be a lot more. Different written submissions, how do you prepare? These are different from the drafting part of the Supreme Court's jurisdiction. Okay, written submissions is a separate thing that you can prepare. There are specific kinds: written submissions, convenience notes, volumes, paper books. Sanchita will explain to you these. Okay, issuance of notice by Supreme Court. If you have got the matter to draft an SLP, your client wants at least notice should be issued. Notice should be issued means other party has to respond and the case is admitted for hearing. Okay, that is what you want. List of, then this is what you will do every week. Okay, Starting with case law research and using a judgment, you will read the High Court order and then say, how do I go in an SLP? How do I go in appeal? You will draft original suit at Supreme Court. You will draft writ petitions. There are 5 categories of writ petitions you will draft. SLP you will draft separate in civil, separate in criminal. Okay, you will draft appeal under Supreme Court Enlargement of Jurisdiction Act. You will draft appeal under NCLAT, NCDRC, civil transfer petition under civil law, under criminal law, written submission. So each one of these you will draft yourself. Okay, contempt petition civil, contempt petition criminal. Supreme Court has power to punish for contempt, and High Court has, right? These 2 courts only have the power to punish for contempt. I think NCLT has some contempt powers, but in Supreme Court this is very, very important to learn for Supreme Court lawyers. Drafting arbitration petitions before Supreme Court, review petition, curative petition, counter affidavit, interlocutory applications. Okay, do you see how these are very specific to Supreme Court? Notes for arguments for you or for your senior advocate, role play simulations, brainstorming sessions. Then there are a lot of chapters you will go through. Okay, study materials will be there, hard copies of the same will also be provided. Okay, very specific points, but there will be study materials. Okay, so that you are actually reading the material to perform the work, and then when you perform the work you get the feedback on it, right? Now I'll just explain to you the method that works, that is used to train. Okay, stay with me. So now this is a 6-month course. I know that I don't have 50 people who've done this and have been successful at Supreme Court. That's going to happen over time, right? But we have people who've done civil, criminal, NCLT litigation and who have been benefiting, right? We have interns who have benefited by interning under AORs, advocates on record. Now the thing is that you will learn how to perform end-to-end drafting work, role plays of arguments and admission stage. How does this happen? This happens in a live class, and there will be some exercises where you'll have to think and plan out what is going to be done in the hearing. There will be mock briefings. This will happen in class before senior advocates. Okay, so the mock will be conducted here by Sanchita. Then there will be a number of more advanced aspects. Okay, now let me explain how the course works. Study materials I've explained, live classes, 2 live classes every week after class hours. This would be on, one class will be on Sundays, another class also, Sanchita will tell you the time. This is basically after 8 p.m. Okay, on weekdays or on Sundays. These are the 2 times that the class can happen. Okay, she will invite renowned senior advocates from time to time to take special guest lectures. Assignments on drafting, briefing simulations, role plays. E-filing process is very important, right, in remote environment. Inline evaluation on your assignments. What does that mean? When you submit a draft, you want corrections, right? Otherwise, how will you improve? So this is not automated online stuff. Okay, this is real stuff. It's not like कि आपको pre-recorded दे दिया. There will be somebody in evaluating it, correcting it, suggesting changes. If you get stuck, even after that, you can book a one-on-one call with an evaluator where you struggle. You will get also assistance on drafting, on building your writing skill. Supreme Court drafting is different. Writing articles and publishing them online are different. You will get guidance and coaching on how to write and publish articles in your name on the internet, and we'll help you publish on blog.ipdoes.in. It is now crossed the biggest law blog in the US, Above the Law. It's crossed the viewership of that. Okay, and we will help you with publishing on blog.ipdoes. There are certain quality requirements you'll have to meet. So we'll teach you to write in a way that this is acceptable. If you want to publish elsewhere, you're free to do so. Okay, advice and assistance on preparation of AOR exam. Those of you who want to give this exam, because the full syllabus is covered. Assistance in finding placements and internships. So you saw that we were giving everybody assistance with that, right? A lot of young lawyers and law students. So that will be available here. If you want to know, okay, sitting in Bangalore or Assam, how can I get connected to an AOR, that you will find that help here. We'll teach you how to network also. We'll help you how to get placements. Okay, and this is exceeding the duration of the course. This is a 6-month course. Okay, you have access for the course for 3 years. Okay, and you learn how to build your network. So you won't have this problem that I'm a first-generation lawyer, not a topper, not from an NLU. All this won't matter, because you will learn skills that matter in the real world. Okay, apart from drafting, you will learn how to prepare for hearings, how to brief a senior, how to prepare notes for briefing. You'll get feedback. Okay, now we'll give you enough simulation exercises to practice. Okay, we'll focus on this, how to use storytelling as a skill during arguments. Okay, and how to drive difficult points home. Okay, you must, now how do you use it? You must aim to continue working with your seniors on an extended basis after the internship. Don't say I'll only do for 1 month. Continue. Okay, I'll give you a pathway how to start this. Okay, we'll train you how to use LinkedIn and Twitter. The course costs 48,000 rupees. There is a 1 month money back guarantee. If you use the course for 1 month and do not find it valuable, you can claim a full refund. Okay, the risk is on us. If you participate in the course for 1 month and after that you find it not to be helping you, in 15 days you can claim the money back. Okay, the money back policy link is here. Okay, Abhishek, can you paste it? I'll just paste on chat. Okay, I can show it later if you want to see. Okay, I'm giving you an easier way. Okay, just stay. Now the thing is that we want to help young lawyers. As we were having this conversation, na, ki, okay, Supreme Court plus other courts or only Supreme Court. How do we build a proper practice, you know, in, let's say, criminal law or civil litigation or arbitration, and you want to combine civil litigation, let's say, with Supreme Court work. So how do you do that? Because you can't. A lot of you are saying, na, how do I jump to the 5th floor of a building, to the terrace of a building without going to the ground floor? Right, and that's what is meant by, okay, how do I learn cross-examination? How do I learn, you know, basic civil criminal litigation? How do I learn basic drafting? Okay, so we don't look at this as a course, but a full-blown career plan for you. And I've been thinking about what will work, how we can contribute to young students. So I can't emphasize enough about how important it is to start early. How many of you agree that it's really important to start early? If you want to start with the basics, we have a special offer, but it's like a really expensive one for us. So we can only restrict it to 10 people. Okay, I suggest that you combine your learning, and I'll tell you how to use specific combinations with other areas of law. So you do civil plus Supreme Court, or you do criminal plus Supreme Court, or you do arbitration plus Supreme Court. Okay, or you do NCLT plus Supreme Court litigation, because then you can do IBC work, NCLAT work, and Supreme Court work. Right? For the first 10 students, if you pay an additional 5,000 rupees, you will obtain a 1-year access to litigation library, which has in all courses worth 3.6 lakhs together. Okay, individually, you will get 1-year access to litigation library also in addition to Supreme Court litigation course. Now I'll tell you how to build some important combinations. Okay, IBC suspension, you know, IBC was suspended for 1 year. Okay, that is being lifted on 31st March. Okay, work on IBC will increase. So if you can do IBC ka work at NCLT, NCLAT, Supreme Court, that is one combination to use. Arbitration plus Supreme Court work will work if you learn arbitration drafting plus Supreme Court drafting. Okay, in arbitration, the matter works completely differently. You can learn international commercial arbitration plus Supreme Court drafting. You can learn all three together. Okay, you can learn tax litigation plus Supreme Court work. You can learn competition law plus Supreme Court. You can learn criminal litigation plus Supreme Court work, civil litigation plus Supreme Court work, or you can learn criminal litigation plus civil litigation plus Supreme Court. Are you seeing the combinations? Or more than one of the above, right? So you can learn all of that also. But in 1 year, how much can you reasonably learn? So think of a couple of practice areas maximum, right? Like arbitration, civil litigation, and Supreme Court, or civil, criminal, and Supreme Court, NCLT and Supreme Court, tax and Supreme Court. Okay, think of the combination that will work. Tax, NCLT, Supreme Court can work. Okay, you will have access to all the courses in the litigation library for 1 year. I will show you the litigation library page also. You can access as many courses. I told you these combinations because this is how people want to use them, right? But you can access all the courses at once. Okay, I'll show you how to search. You want to see what's there in the litigation library? Okay. Stay till 9 if you want to claim the free offer for the free recording. And there's one more thing I want to show you. So you think that you've heard it all and you can go, then you may miss the offer. Okay. So this is the litigation library. You can take a look at the courses on this link. Abhishek, can you share a link to the litigation library?
Yes,
this is
sure.
to understand what are the courses in the litigation library that are available. Okay, there are about 15-20 litigation courses that are there. Now you can access as many courses as you want at the same time. I have explained to you the paths that you can build. Okay, how to customize it for yourself. The total fee will be 53,000, but I have a very easy way to pay for it. Okay, you can take a loan from Bajaj Finance. We have a collaboration with Bajaj Finance. Interest cost you don't have to bear. Within the amount, your interest cost will be absorbed by us. Okay, so your total installment plan will be this: a 10,600 down payment and 𝘲𝘢𝘺�34 per month for 12 months. Okay, so imagine this: if you get an internship, and with all our recruiters, okay, the placement committee has a collaboration. Simple one: if you go for an internship from the second month onwards, if the intern has done a good job, please pay them 5,000 rupees. Okay, otherwise, if the intern has not done a good job, you can terminate the internship. Okay, so it's very clear, and based on that, what happens is, if the intern is willing to work after that, they earn a stipend. If you are earning 5,000 rupees as stipend, you are earning more than this. If you work for more than a couple of months, people start paying you more if you're contributing, right? So you may even earn 8,000, 10,000. In fact, it is not difficult for law students to earn 10,000 or 15,000 per month. You should look at doing that. Okay, now that will enable you to earn the cost back. You can easily afford the EMI also. With 5,000 rupees of stipend, you can afford the EMI as well. Okay, now if you want to block this offer, simple thing: right now you can make a down payment of 7,000 rupees. This is available only to the first 10 people who do this. Okay, our team will contact you to help you out with the loan, or if you want to make the full payment, you can do that. To block your seat, this is the link. LawSikho.com/offers. I'll just wait for it to load. So what you need to do is just pay 7,000 at the moment. Okay, and our team will contact your seat and your offer gets locked. So litigation library plus Supreme Court litigation for a month. Yeah.
I have shared with participants.
Yeah, but it's not loading here. I think there's a bandwidth crunch.
Oh.
Okay. So I would suggest those of you who are interested, you can block your seat now with 7,000 rupees. Okay. After that, our team will contact you if you want to block the offer. Okay. Otherwise, the course price stays at 48,000, and if you are the 11th person, the offer won't be available, right? Then you can only get access to the course. So 5,000 more, and you can claim the offer directly, right? That's available for first 10 people. So I'm waiting for the site to load.
Do you want me to do it, Abhyuday?
If you can, that'll be great. I'll allow you to share screen. Thank you. I think it's not loading at the moment. Okay.
Yeah.
So I'll continue.
Yeah. I'll stop sharing.
Yeah. Okay. So those who want to go on the offer page, you can type this link. I'll wait right now. You can go there and make the offer, or you can claim the offer now. Balance payment can be completed when our team contacts you, they'll tell you, okay, what documents are needed for the loan and all of that. Interest, all of that, all the interest that Bajaj charges, that we will be absorbing. So you don't have to pay additional interest. Okay, balance payment must be completed by 8th. Today is the 4th, so there are about 3 days to complete it. But if your loan documents are approved, you will get it. Okay, so that there won't be a problem with that. The batch is closing on 14th. Classes start on 15th week onwards. Okay, now here's how to use the plan for those of you who are interested. After enrollment, our team will help you identify the areas of specialization and what to bundle this with. So how to use litigation library and Supreme Court litigation to your best advantage. Focus on the specialization. Okay, but you will have other courses in the litigation library, all classes. You can attend as many classes as you want. Okay, all of them will be available for reference. Okay, you'll get hard copy of Supreme Court litigation. The others you have all access online. You can attend as many classes as you want. You can submit exercises and assignments from other courses to get them evaluated, to get guidance. You have opportunity to write and publish as many articles as you want as well for 1 year. Okay, you can start learning from day one. Now, internship, job, and client opportunities will also be shared from day one. We have a group where we do that. Prepare for an internship around days 60 to 90. We have seen that it takes about 2 months to get a little better than the average person who applies who's untrained. Okay, you will get good enough to get responses at this time. We will teach you how to make internship applications, what work to show. You will submit your draft petitions to the seniors you want internships with. Okay, so prepare for your internship to send internship applications around 2nd to 3rd month. Then your focus has to be, when you get a confirmation, you want to do well. Either extend the internship and start earning your stipend, Minimum stipend recommended is 5,000 per month, which our placement team recommends to the seniors. So those who find the interns valuable, they will pay that. If you don't enjoy it, continue to look for alternate internships. Our team will help again. It's not that you'll get only one internship. We will help you out. So if you're in Bangalore, any city, we will still help you out with this, right? You don't have to worry about how do I find, because you have to just follow the requirements in the course. Continue to work remotely alongside college. Okay, the pandemic has led to a higher comfort level for recruiters in remote scenarios. You all are already aware about this. So if you continue for a longer time, your stipend will increase, and that is how you start to gradually go independent. If you're earning 10-15,000 in college only, then after graduation, you will know that you will have a lot of confidence about pursuing independent practice. You'll be able to pay EMIs with that money. You'll be able to generate pocket money because you'll have a net difference that you can retain. You'll be able to learn. You'll be able to build a network with seniors whom you may want to work with once you graduate. Sanchita already shared that she worked with seniors whom actually she had interned under, and you will be able to expand on this and do it faster, because all the learning that she had to go through trial and error, plus learning of various senior advocates and retired judges, is captured in the course. And you will learn way more than the average lawyer does, and way faster. That will speed up your growth. It's possible to earn 10 to 20,000 during college if you're helping litigators. Then it gets stuck. Okay, so now I'm going to ask you questions about how can you use this kind of learning. Okay, how can you use this kind of learning? Okay, we will send you the link. Okay, you can contact 𝘬𝘪 if you want to claim the offer. This is available only till midnight today for first 10 people. So you will need to write to 𝘬𝘪. He will share a private link if the site crashes. A lot of people are trying to reach. Okay, so you send a link to 𝘬𝘪, to a message to 𝘬𝘪 on the number written here, 8439572315. Okay, and he will help you out. Now I want to take this question from you, that which areas you want to build a practice in, how will you go about building? Yeah, so your goal has to be this, that in college you are good enough, you're confident enough, you can think of going independent. Now if you can think of going independent, then what happens is you can join a senior advocate directly. You can do the thing that Sanchita couldn't do, 6-7 times more 6 months earlier. Literally, that stuck in my head. Okay, so you can do that because you can continue to get independent matters on the side. All right, so I would invite all of you to please reach out to 𝘬𝘪 if you are interested in claiming the offer. Yeah, I got Shubham, you're not able to reach. P. Ravi, you're not able to reach on the offer page. Okay, great. So I think there's a big rush, so it will be good if you call 𝘬𝘪 directly. Okay, I'll take some questions in the meanwhile. Okay, and Sanchita and I will take questions together. Tanvi can't open. Okay, let's just see the Q&A page. Okay, so how do you want to go about questions, Sanchita? I'll shortlist. Okay.
Yeah, please.
I'm looking at the Q&A panel only, not at the chat for questions. Okay. So we have dealt with how to join a Supreme Court lawyer. A lot of questions that you said that were asked by participants have been addressed. Any pending questions? Please point to your questions if something is pending. Okay, Sarita is not able to open the link. Sarita, you take the number. Okay, everybody, please take 𝘬𝘪's number if you are interested in knowing more. Okay, then 𝘬𝘪 will help you out. His number is mentioned on chat. Okay, are there specific questions that you all have that we didn't address? It will be great if you all can bring those questions forward right away. Can you explain about tax litigation at Supreme Court?
What is it exactly? If you can just guide me, Abhyuday, what would...
Okay, they are basically Supreme Court's jurisdiction in tax is on SLPs also from various orders of High Courts, and there is an appellate part of the jurisdiction on certificate of reference from High Court. Okay, these two things are done at the Supreme Court if you're doing tax work. if the tax angle goes under criminal law, then there may be some criminal appeals that may be there. Otherwise, mostly it is SLP related work. Okay. Any other questions? Yunus, where should you start? Should you start in trial court or not? We have explained that. Okay. Sushil, does master access cover this course? Yes. Anjali, if you have inclination towards towards constitutional law, then Supreme Court litigation is what you need to learn ASAP. Okay. Okay, Sarita, if there is a challenge, you can look at exploring the litigation library, and this course will be with that. Okay. Okay, so I'm going to stop the live session. If you all have any questions, please let us know. I'm here for about 5 to 10 minutes with